the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Whoa. I had to fix my chair for a second. All right. They put me at the kids' table, I guess. Good morning and welcome to the Appeals Court. I am Chief Justice Amy Blake. To my right is Justice Eric Neyman. To my left is Justice Marguerite Grant. We are the panel that will be hearing the 6 cases on the list today. I'm just going to go over a couple of ground rules, although I know most of you have been here before. Each side is permitted 15 minutes of argument. There is no rebuttal. I can assure you that we have read all your materials, so my recommendation is you get right to your arguments. We will hear the first 3 civil cases and then take a brief morning recess and then hear the remainder of the list. As you know, the cases, for those of you that haven't been here before, will be taken under advisement. There will be no decisions today. Each case, will receive a written decision sometime in the future. With that said, I will call our first case of the day, YARI JUSINO versus the Massachusetts Chiropractic Center, LLC, and another, docket number 25P369. Counsel for the appellant. And I understand you filed your appearance yesterday, this week.
No, Your Honor, that was counsel for appellee.
Oh, I apologize. Okay, so you've been in the whole time?
Since the BMC appeal.
Perfect. Okay, Attorney Doherty, when you're ready.
Thank you, Your Honor. Good morning and may it please the court. My name is Anastasia Doherty and I represent the appellant, YARI JUSINO. This case is about my client, Ms. JUSINO, who the defendant paid $15 an hour to work as a patient care coordinator, having weeks...
Say $15 an hour.
Yes, Your Honor.
The time records reflect a payment of $13 an hour. So where do you get the genuine dispute of fact that suggests there is evidence that it was $15 an hour?
Ms. JUSINO attests in her affidavit in the record that the employer agreed to pay her $15.
Do you have anything other than the affidavit? Any other evidence?
No, there's no documentary evidence that Ms. JUSINO submitted on
And
that.
at what point did he promise to pay her $15 an hour as opposed to the $13 an hour that is reflected in all of the pay records in the appendix?
Well, for clarity, Your Honor, there is one paycheck in the record, and that paycheck is issued 45 days after Ms. JUSINO resigned from employment, and she...
So where in the record is the evidence that he was to pay her $15 an hour other than the affidavit?
Well, we can't discredit the affidavit, Your Honor, at the summary judgment stage.
Okay, my question, though, is there anything other than the affidavit?
No, we rest on the
Does the
affidavit.
affidavit make any specification of when he made this promise or in what context or anything else, or is it just a statement, he told me I was making $15 an hour?
The statement is he agreed at the outset of my employment to pay me $15 an hour.
Well, that affidavit is dated 2024, about 5 years after she left employment. Is there anything in the record that's closer in time to her leaving employment that shows that she was making $15 an hour?
You could look at the email that she sent to the defendant requesting that he pay her wages. That was sent on May 10th, 2019, and she includes an estimate as to what she's owed, which is $14.10. And we know from the record that that's at a $15 per hour rate because she estimates 94 hours of unpaid work, which is documented by handwritten notes.
But that reference to the 94 hours also included work for an entity called Union?
It's not clear in the record. It seems to, but it's not clear. But Ms. JUSINO's position is that this employer, this entity, owed her for those 94 hours.
Including the time she worked for Union?
Yes. But
Union isn't named in the complaint.
That's correct, Your Honor. But this case is about her having those wages withheld, whether it was at a $13 an hour rate or a $15 an hour rate. It is undisputed in the record that this hourly employee who made $13 to $15 an hour had weeks of her wages withheld.
So speaking of the affidavit, your client writes or avers in an affidavit on March 21st of 2024 that on or around June 7, 2019, she received a check in the mail she picked up in the post office in the amount of $1,586, and when she attempted to deposit the check, it bounced. She then files a supplemental affidavit 4 days later that says, I do not recall ever cashing the check dated June 7, 2019, and to date I am informed and believe I have not received the funds from the check dated June 7, 2019. Who informed her that she had not received the funds from the check?
That sounds like it may be clumsy wording in the affidavit. I would emphasize that the June 7th tender is immaterial to a determination on liability under the Wage Act.
I appreciate that. Can you answer my question? Who informed her that she had not received the funds from the check?
I do not know. I believe that is based on her personal knowledge, so it is testament to the fact that she did not receive the funds. And you can see that in the bank records she submitted, that it bounced. She incurred a $12 fee when it
I am
bounced.
informed and believed I have not received the funds from the check dated June 7th, 2019, but in her prior affidavit, she said the check bounced.
Correct. So part of what may help understand this wording is the defendant moved for summary judgment saying, we issued a check, Ms. JUSINO cashed the check. Then in opposition, Ms. JUSINO explained, when I tried to cash the check, it bounced. And you can see that again in the bank records. You can see it bounced. She got the $12 fee.
And then there was a hearing before Judge Coffey, and then she filed the supplemental affidavit saying, I am informed. Do we have a transcript of that hearing before Judge Coffey?
No, but it was not an evidentiary hearing. So, and this is one of the problems, right, on summary judgment, that the affidavit was discredited without any live testimony. We don't have any depositions in the record, and there was no evidentiary hearing. But I would like to impress upon
But
this.
actually, speaking of that, we don't have the entire summary judgment record, do we? That's your burden as appellant. We have pieces, but how do we decide this case without the full record?
It seems it starts like around Exhibit 8, if I'm not mistaken.
Correct.
So I guess Chief Justice Blake's question is, do we have the entire summary judgment record before us?
The entire summary judgment record regarding the appeal on the entry of summary judgment is included in the record. There was
That's yes or no. Do we have the entire summary judgment record from which you've noticed an appeal?
not all exhibits from the lower courts are in this record. It can be supplemented if the court would like.
The burden's on you. So I don't know how we decide this case without a full record.
My understanding of the appellate rules was to include the portions of the record to be considered on appeal. Again, I'm happy to supplement the record.
So only the things that are favorable to your client?
No, Your Honor. Not only things that are favorable to our client, we certainly included the image of the check that the court has asked questions about being negotiated. I would, understanding the court has questions, I would emphasize that Section 150 of the Wage Act does prohibit consideration of the June 7th check that we've been discussing as a defense to Wage Act liability.
When was the defendant served with the complaint in this case?
I'm sorry, I couldn't hear you say that again.
I'm sorry. What date was the defendant served in this case? The defendant being Mr., and I'm going to mispronounce his name, but Sapozhnikov.
There were service issues below, so it's not clear when Mr. Sapozhnikov was served. The entity, MCC, was served on June 20th.
Okay. What date did he make the payment?
The check is dated June 7th.
Is there any evidence in the summary judgment record that the defendant was aware of the lawsuit prior to being served on the 20th?
There's no evidence in the record, but I would say, Your Honor, there's no notice requirement for Section 150.
That's kind of why I'm asking. It seems to me your argument, which is very understandable, is this. This is basically almost like a strict liability statute, and it basically says you don't pay on time, you owe. And that includes treble damages and attorney's fees. But I believe there's also some case law that suggests that if payment is made prior to that, before someone was aware of the lawsuit, and the lawsuit was not the catalyst for payment, that there may be a carve-out for payment of attorney's fees.
So Section 150 actually limits the defenses available to employers to only 4 defenses, none of which are applicable here. Valid offset, assignment, employee not at the workplace, and actually getting wages at the time they're due. So those are actually the only defenses allowed under the Wage Act. The legislature went a step further to explicitly say post-complainant tender of wages cannot be used as a defense. Again,
Say that again. I'm sorry. Post what? I just want to hear that answer.
Post-complaint tender of wages cannot be used as a defense
Does
to liability.
post-complaint mean post-filing or post-service? I know you said notice isn't an element, but again, if someone makes payment before knowing of a complaint that has been filed, I mean, it seems to me that that would be a different situation.
Well, SJC has spoken to this in Dixon and Router. So in Router, the city terminated the employee for being convicted of larceny. They did not pay the employee her owed wages on the date of termination. Instead, they paid those vacation wages 3 weeks later. Then, after receiving a demand letter from counsel, they paid treble damages on the interest owed for the delay in payment. And the SJC opens its Router opinion saying, this is not a liability case. It's clear the city violated the Wage Act by failing to pay those vacation wages owed when she was terminated.
In that case, it was after they received notice, correct?
Well, not the vacation wages. So they're saying this is a pure measure of damages. Even if we were to rule that they have paid her statutory damages, liability has already been determined here. And the SJC speaks to this as well in Dixon, where it says unequivocally, an after-the-fact gratuitous payment, or I'll quote, the damage done by not being paid your wages on time cannot be mitigated by gratuitous after-the-fact payments. And in Dixon, I'll note that the city actually paid that plaintiff more than the plaintiff was owed or could recover under the Wage Act.
Well, what if the June 7th check here had been for $1 million? If the employer just said, I want to be done with this case, she says we owe her $1,410, we're going to give her $1 million. And it was cashed. And your client insisted, no, it's still the wrong amount, it's still the wrong amount. We still have disputes of fact. Could your client just keep running up attorney's fees and just disagreeing with the fact whether the amount was appropriate?
Section 150 in Dixon prohibit the use of that payment as a defense to liability, and in the hypothetical
Is it
that...
also a defense to the attorney's fees?
No, because upon a finding a liability, it is a mandatory award of attorney fees. That said, when a court considers what attorney's fees to award, it considers what's reasonable attorney fees. And part of determining the reasonable time spent on the case is looking at the result achieved. So that is the proper vehicle under which to consider the attorney fees in this case.
That's really what this case is about, isn't it, your attorney's fees?
No, our client avers that she never got the funds from the check, and I would like to make the point, which is...
What did she do when there was an allegation that the funds had been negotiated? Did she file, there's some claim that maybe the check got dropped and someone picked it up and cashed it. Did she make any kind of a police report? Like, what did she do to sort of put up her flag to say, yeah, maybe the funds were negotiated, but I never received the money? What did she do?
There's no evidence of that in the record. I would like to emphasize the point that the check, which the defendant describes as being for $1,586, is actually a check for $1,086 because he deducts, assumes the $500 cash advance can be an offset and deducts that. So defendant estimates that my client's owed $1,444. We estimate she's owed upward of $4,000. Under neither version of those facts is that check actually a tender of treble damages.
You can just see, though, why the BMC judge was a little bit, let's say, miffed by this story. She's sending letters to this person saying, you owe me $1,400, after the filing of the complaint. She says, I need this money, I can't pay my bills, I have nothing. And then she comes back, geez, I'm informed, I don't know. I believe I didn't cash that check for the 1,000 however many dollars. I mean, if someone is literally can't pay their bills, has no money, and then they don't know whether or not they actually cashed and deposited a check in that amount of money, I mean, that's highly suspect. But I understand at summary judgment, we must accept the facts as pled.
Yes, exactly, Your Honor. You must accept the facts as pled.
As averred, I should say.
But with 90 seconds left, I would like to emphasize the Wage Act is meant to protect workers like my client who live paycheck to paycheck. She had weeks' worth of her wages detained for 45 days after her resignation. Her bank records are in the record, and you can see the effect that it had on her. And I would just close by saying, I urge this court to reverse because the outcome that the lower courts reached is not allowed under the plain language of the Act and the SJC decisions. It is not fair to my client. It is not the public policy of the Commonwealth that the legislature has reached and expressed through the language of the Act.
Policy doesn't control this case.
No, it does not. You can look simply to the plain language of the Act.
Question from the panel, Chief. I have another question. You may go over, but the day after the filing of the complaint, so the complaint was filed on May 9th. On May 10th, your client sends an email to the defendant saying basically, you owe me $1,410. Please pay this now. Is that a fair summary of what that email says?
Please, really, I would appreciate it if you pay me my wages. I'm falling behind on bills, correct?
And she specifies the amount of $1,410.
Yes.
Okay. Why should that email not be construed as an offer to settle when it's filed or when it's sent to him post-complaint? And he then tenders her that amount, but go ahead.
So this was a series of requests made by the plaintiff. You can see her text exchanges in the record at 80 to 82. She asked while she was employed for her wages. She asked the day after she resigned for her wages.
So my question is with respect to the May 10th email saying, after the complaint has been filed, pay me the $1,410 you owe me. Why should that not be construed as an offer to settle?
Because it doesn't address all the damages. As Chief Justice Blake pointed out, there are fees and costs that she is owed under the Act, and
she didn't put that in the demand. She said, pay me $1,410.
Well, I'll point out that this paycheck was not issued or is not dated until June 7th, and there's no corresponding letter.
Prior to him being served the complaint. So he doesn't even know about the complaint at this point in time, as far as the summary judgment record tells us.
So I suppose the clearest answer to your question is that she asked for $1,400, and the check is for less than that. So it cannot be considered an acceptance of any settlement offer.
So you're saying the withholdings shouldn't be counted? They shouldn't have held withholdings from her wages for taxes?
The $500, is that $500 disputed, that $500 prepayment he made to her? Is there a dispute of genuine fact?
No, there's not a dispute of genuine fact in the record. The issue is that it's double deducted from the paycheck in their calculation of the damages.
Let's assume that the check issued on June 7th and that she endorsed it and dropped it on the street and somebody else cashed it. How is that a violation of the Wage Act by the employer?
Because the employer paid her wages 45 days late. And this is the point that I would really like to emphasize to the court. The injury that a worker incurs under the Act is the delay of payment.
So if the employer paid her 45 days late and she took the money and went to Foxwoods and lost it, would that be a violation of the Wage Act?
Yes. It would be a violation of the Wage Act. And I think one of the points of equity that the court's getting at is, will this check be able to offset the damages? Perhaps, and that's something the SJC says in Dixon in a footnote when The city there is complaining, this is going to give the plaintiff a windfall. We've already paid him.
But the Judge Coffey and the Appellate Division have already concluded that that June 7th check represented more than the damages owed to her under the Wage Act. How do we second-guess those findings if we don't have the complete summary judgment record?
Well, it is de novo review. The records regarding the tender of payment, the disputes regarding the pay rate and the hours are in the record. So I would say that it was an erroneous conclusion below to find that she had been paid her statutory treble damages under, again, neither party's estimation of the damages. Does the check amount to treble damages? It's not labeled treble damages.
We should do the math. We should calculate the arithmetic now and make our own findings.
Well,
You're not arguing that. You're arguing that there's a dispute of fact and this needs to be remanded for a determination.
Well, first and foremost, I'm arguing that the Wage Act does not allow that tender to serve as a defense to liability. The Wage Act provides treble damages and costs and fees, and that's because the legislature does not believe a worker should have to hire an attorney and pay for an attorney to recover wages she is indisputably owed. It costs $205 to file the complaint. Those are costs that Ms. JUSINO deserves under the law and should be awarded, and there was no consideration of that below.
You didn't cross-move for summary judgment yourself, correct?
Correct.
So you're asking for us to remand. You're not asking for us to make that determination ourselves.
We are asking you to remand on all the claims. We would ask for an instruction on remand that judgment as to liability on the Wage Act claim enter in the plaintiff's favor, which is a permissible approach to take. That is something the SJC did in Dixon when it was considering the issue, so that is our request.
Thank you very much. Attorney Horn. I apologize. You're the one with the late breaking notice of appearance, and we're glad to have you.
Thank you. Good morning, Your Honors. My name is Ernest Horn, representing the appellees in this matter. The gentleman, Mr. Sobinskov, suffered a massive medical emergency. He had gone to his primary care, wasn't feeling well. And then at some point, they sent him to a cardiologist for a stress test. And as a result of that stress test, he was taking...
He had quadruple bypass surgery.
Yes.
We understand
Okay.
the facts, and
Yep.
you have wonderful policy issues in your favor, and it's arguable that the statute here is doing your client an incredible disservice. But that's not the issue. The issue is whether or not, when he failed to make payment, even though he was undergoing quadruple bypass surgery and perhaps couldn't have made payment, whether his failure to set up some mechanism to make payment to his employee or to pay her wages on time constitutes a violation of the Wage Act. So what do you say to that?
This was an unforeseen event. He was the only individual that was handling payroll. In fact, he was the only
Does
individual.
the Wage Act make any exception for unforeseen events?
I think that there has to be an understanding for unforeseen events. So what if a company had 500 employees and they would do payroll on a Wednesday and the building burnt down? I mean, there has to be...
There anywhere in the Wage Act where we can find that carve-out, and if not in the Wage Act, is there anything under Massachusetts case law, any exception like that that exists anywhere in any published case?
I'm not aware of any on that, Your Honor. I think that the lower court found that his behavior was not unscrupulous, which I believe is what the legislators were trying to protect from, someone who is acting unfair, unreasonable, and he certainly wasn't doing that. In fact,
Isn't the Wage Act, these are my words, a strict liability statute? To Justice Neyman's point, you have lots of equitable arguments, policy arguments. I'm guessing opposing counsel, you know, she's not saying your guy went to Tahiti. No one's questioning what happened from a medical perspective, but we don't have a statutory carve-out, and I am unaware of any cases that allow us to do that. I guess you're asking us to do it perhaps for the first time here, which is more of a question for the second floor than this floor, but what do we do?
These matters were addressed in the lower court. The court looked at it. They found that he did not engage in unscrupulous behavior, which I believe was the legislative intent. It wasn't a catch-all to just catch anyone. It was for people that were doing evil, as some of the case law says. And he wasn't doing evil. In fact, the argument...
What case says that? I just don't remember.
I don't have it right off the top of my head, Your Honor, but there is one, I believe, in... and actually, I should note that I did not do the brief.
I know.
Okay. But I believe that there is some in there regarding evil. You know, our position is that as soon as he realized, well, as soon as he was capable of thinking and engaging in any meaningful employment activities on that 7th day of June, he issued a check. He hadn't, to the best of my knowledge, he had no information about a case pending against him. He had no information that he was going to be going to court. Not aware that he was served. In fact, I'm quite sure he wasn't served at that point. So she sent him communication that she wanted the money. He wrote that check, and in fact, he actually wrote it for more than he needed to. He wrote it for $1,586. He did reduce it by $500 because she had taken some sort of a cash advancement on one of her paychecks. And the record was, my understanding is quite clear that he was paying a $13 an hour, not $15 an hour, and the records presented indicated that that was what the payment was. And my understanding is that there was no evidence provided from the other side indicating that it was $15 an hour or any other information.
Why is her statement in her affidavit, let me actually get the language so I'm not paraphrasing. Why is the language in the plaintiff's affidavit where she says, at the outset of my employment, MCC agreed to pay me $15 an hour for all of my hours worked? Why is that not sufficient to create a disputed issue of material fact or a genuine issue of material
I think that the payroll records provided by the appellees at the lower court showed that she was always paid $13 an hour. She was never paid that and never rebutted it.
Right, but she's saying that's incorrect. It should have said $15 an hour. He made that promise to me.
Well, if that was the case, then why didn't she argue that in earlier paychecks? She had worked there since, I believe, January.
What's Union Cairo?
I'm sorry?
Union Cairo. She said she worked for MCC and Union. What is that entity?
I unfortunately don't have any information on that, Your Honor. I don't know the difference in them. I apologize.
So even if we were to conclude, as did the BMC judge in the appellate division, that the plaintiff was made whole, why is she not entitled to attorney's fees under the Act?
I think that we go back to what the court below ruled was, they believed was the legislative intent. It was a shield, not a sword. It was designed to deal with unscrupulous employers, and we certainly know that those exist out there. And that was not the case here. This was, it caused an impossibility for him to comply at that time. No different than if the building burnt down and they couldn't do payroll. There has to be some understanding that we live in a world of human frailty, and from time to time, there are going to be things that perhaps people didn't predict or think about when they wrote something, but the court did indicate that this was not what the legislative intent was. It may not specify specifically in the language, and it certainly doesn't, but the court held that that was not the legislative intent to penalize people who were not acting unscrupulous or being deceitful or engaging in evil behavior.
Do you think the statute should be amended to include malicious intent on behalf of the employer?
I don't. I think actually that the courts have to have the ability to look at just like as we all know, you have to look at each case individually and look at the specific facts and render a decision based on what you see. And, not everything fits into a perfect square or round hole. And that's why we have the courts. The judges have to look at these things and say, is this an exception?
So the Reuter versus Methuen case from 2022 at 468 says, and I'm going to quote it so I don't screw it up, because of the potentially severe financial consequences of even a minor violation, the Act not only protects wage earners from long-term detention of wages by unscrupulous employers, but also imposes strict liability on employers who must suffer the consequences of violating the statute regardless of intent. So on the one hand, you have this reference in Methuen to the detention of wages by unscrupulous employers, but in the same sentence, the SJC recognizes that someone like your client, regardless of intent, it's strict liability. And doesn't that handcuff us?
It is something that the court has to look at, but you still have to consider the fact of impossibility. If someone is incapable of doing it at that moment, if that company burnt down and it had 5,000 employees, do all 5,000 of them get triple damages if they're paid 3 days later when they find an off-site payroll service to pick up where they left off? I think that
Is impossibility a defense to a strict liability statute?
I apologize.
Sure. Is impossibility a defense to a strict liability statute?
I think there has to be. There has to be some exceptions that the court must consider based on the
And I'm
legislative.
going to ask you the same question I asked you earlier, because that's an interesting concept, but are there any cases in Massachusetts which say as much, that in the context of a strict liability statute, impossibility may still be a defense?
I'm not aware of one, Your Honor, but I think certainly under the theme of contract law, impossibly able to perform, some action, not by your own doing, by some unforeseen event, I would think that would be something that the court would consider in this type of case.
So the appellate division says something to that effect at Record 105. The judges say, under the extraordinary circumstances in the case at hand, where the defendants failed to make a prompt payment as required by the statute due to an extraordinary medical emergency, a strict liability construction of the statute would yield an unreasonable and unjust outcome inconsistent with legislative intent, which is to protect employees and prevent the unreasonable detention of wages. And they cite Boston Patrolmen's Association from 2002, but I don't think that case necessarily stands for the proposition that the appellate division cited it for. Are you aware of any case that says that application of strict liability would yield an unreasonable and unjust outcome, and therefore we don't have to follow it?
I'm not aware of a case, and I do agree that that particular case was about deferred comp or something.
Right.
I didn't understand it myself.
Okay.
But
Glad it wasn't
I
just
don't know
me.
that I'm aware of that, but the courts always have to make equitable decisions based on the facts. And that court indicated that it was their opinion, which is certainly my opinion, that it was not the legislative intent to skewer every person with a sword in every situation. It's difficult for the legislators to come up with a law that thinks of every what-if possibility. And I believe that this would be, I believe this is a perfect example of something where the court has to use their discretion.
I see you still have 3 minutes. I don't see any other questions from the panel. We're happy to take the rest of the arguments on the brief if you'd like.
Just, Your Honor, we'd ask that, relying on the appellee's brief, and we'd ask that you affirm the lower court's decision.
Thank you very much. Counsel, thank you both very much. The case is under advisement.
Thank you very much.
Our next case is BRIAN COPPENRATH and another versus Scott HANNULA as chairperson of the town of Carver and others, docket number 25P340. Good morning. When you're ready.
Thank you. May it please the court, I'm Margaret Sheehan, pro bono counsel for Kelsey and Brian Coppenrath. Unless the court is prepared to find that disturbing a person in the most personal and private place, their home, is not substantial harm, then it must reverse the decision below. The certiorari statute is the only means by which the Coppenraths can pursue their right to be free from the harms.
Well, first, we don't make findings, just so we're clear, right? An appellate court doesn't make findings. But could you tell me what the particularized harm is to the Coppenraths?
Sure. As testified to in Mr. Coppenrath's affidavit, they are described in great detail. The harms
Well,
are...
the judge below found there was no particularized harm, that the injuries were speculative. So could you be more specific?
Sure. The judge below found that the harm to the Coppenraths from the dust, vibration, and noise that they experience in their home that deprive them of the ability to enjoy their property, the judge specifically found that those were not hypothetical or speculative. That is in the motion to dismiss decision. The illogical conclusion that the trial court reached on that finding, despite finding that those were, in effect, concrete harms, the court found that they could not determine how those harms actually harmed Mr. Coppenrath and his
Well, I don't know
family.
that that's what Judge Grant said. I think he said,
Judge Gant.
Judge Gant, I'm confusing my colleague here. I thought she sat in both courts. What I thought the judge said was, at page 5 of his decision, that the Coppenraths raised concern about contamination of private wells, airborne release of harmful silica, infestation of predatory animals, ruination of natural vista, and decreased property values. He makes that finding, but then he says, and this is the disconnect for me, and this is where I need your help, these injuries are hypothetical, as the Coppenraths seem to assert in their complaint, only ones that could potentially occur in the future. They provide no information to suggest they have actually occurred or will occur, and that's what we need to be looking at. So help me with that. What in the record shows us that these actually have occurred or will imminently occur?
Your Honor, that is correct, but I would like to draw the court's attention to the harms that the trial court found were not speculative and not
You
hypothetical.
don't want to answer my question.
Excuse me?
Do you not want to answer my question?
No, Your Honor, respectfully, the complaint alleges those harms.
So are you conceding that those are speculative, the ones I just listed out? Or
I'm
you
not-
want me to look at other harms?
Yes, Your Honor.
Okay. So what other harms, tell me which ones are non-speculative.
Those would be the ones that the court found on page 6 in the record appendix, or the addendum, page 35.
So the traffic-related noise?
The concussive noise and vibration from earth removal operations and trucks that the court said occasionally shake the Coppenrath's home, and increased dirt and dust that occasionally blows onto their property, which in fact Mr. Coppenrath testified to as daily harms.
And so what the judge erred in with respect to that piece is the judge concluded that the complaint and the affidavit don't raise those beyond a generalized nature of what others in Carver or others abutting or traveling on Tremont Street may also experience. Is that the error?
Well, the error was first finding that these were not speculative or hypothetical. The court found that these...
But these aren't really findings, right? This is a motion to was this a 12B6 motion to dismiss?
12B1 and 12B6, motion to dismiss based on the complaint. and the-
12B1, that's right.
Right,
So-
on the affidavit. That was unrebutted.
And there was no evidentiary hearing, right?
That is correct.
So this isn't summary judgment, this is just a motion to dismiss, and the question is whether the averments in the complaint are sufficient to state a claim, correct?
That is correct, but also supported by the affidavit of Mr. Coppenrath, who testifies to the personal lived harms that he experiences. That affidavit was unrebutted.
And they must rise to a level of causing particularized harm.
Correct.
So my question is, are the Coppenraths direct abutters to the defendant property?
Yes, they are. They are across the street. They are identified as abutters. This is uncontested. They were provided with a butter notice under the earth removal bylaw as required by the bylaw. And to go...
So how is, now, could you answer, I think, Chief Justice Blake's question, but I'm going to restate it a little bit, which is, how are the things they are actively experiencing different from those that all other neighbors and people experience? When trucks drive by, there's vibration, there's noise, there's going to be some dust. How are these particularized to your client in terms of what was pled here?
They are particularized as described in his affidavit. As the court found, I want to emphasize, or that the court ruled in this decision, these injuries from noise, dust, and vibration are not speculative or hypothetical. That's on page 6.
Under a 12B1 motion to dismiss, do trial judges make findings?
They
Are these I'm not being facetious. Are these actually findings, or is the question simply whether or not they're sufficiently raised in the complaint and the supporting affidavit?
I can only speak to what this appeal is based on, and that is the court's conclusion, which we allege was erroneous, that based on the complaint and the affidavit, there had not been sufficient evidence of particularized harm. So we're looking at the affidavit because it is a 12B1 motion, and it was before the court.
Did the cranberry bog exist before the Coppenraths bought their home? I know it's a new owner, but the bog was already there, yes?
There's an extensive bog complex there, and as the complaint alleges, which the court did take as true all the allegations in the complaint and the inferences drawn therefrom, but there has been cranberry bog farming there for a number of years, but there's also been extensive earth removal starting in 2006. So to go back to the particularized harms, they're not speculative or hypothetical, just focusing on the noise, dust, and vibration testified to in the affidavit. Those were found, well, the court ruled they don't provide sufficient standing. The court indicates that it could not determine how Mr. Coppenrath and his family were actually harmed by those harms that the court found were not speculative or hypothetical. That is the disconnect. That is the illogical part of this decision.
Are you familiar with the Stone case, Stone versus Zoning Board of Appeals of Northborough, decided by the Supreme Judicial Court in July?
No, I'm not.
Okay, thank you.
We are asking the court to overturn that decision that these concrete harms are not particularized, to turn to the question of the generalized nature of the harms. The court misapplied the Fisk case. In this case, Mr. Coppenrath testifies in his affidavit that he suffers noise, dust, and vibration that wakes up him and his family. They are nearby. They are near the entrance to the truck route where now 140 trucks a day hauling sand and gravel are going in and out, starting at 7 a.m., continuing for 10 hours a day, picking up speed and emitting dust as they pass by his home, interfering with his ability to sleep and waking up his young baby, his infant, and his young child from their sleep. Not everyone in the town of Carver lives that close to the sand and gravel mining operation and the truck entrance were, again, 140 trucks a day, and this is 6 days a week, 10 hours a day during the week, starting at 8 a.m. in the morning on Saturdays and continuing until 1 o'clock. This is near daily.
At page 23 of your brief, you make an argument that the decision below, you say, quote, sets an insurmountable bar to common harms caused by government action. Can you explain that to me?
Sure. There's no doubt that these types of industrial scale earth removal operations cause substantial harm. The appeals court itself in the Coppenrath case, Coppenrath versus AD Makepeace Company in September of 2025, identified the types of harm that this particular bylaw, the Carver earth removal bylaw, is intended to address. And the court identifies dust and vibration and noise as harms from this type of operation.
Did you cite that case in your brief?
No, because it was decided after.
Did you send a 16L letter?
No, I don't, but I'd be happy to.
Well, not at this point.
Is that a Rule 23 decision, or is it published?
It's a Rule 23 decision. At this point, the SJC has deferred its decision on further appellate review.
Thank you.
But the case gives an extensive explanation of the purpose of the bylaw and how it is intended to prevent the types of environmental harms at issue in this particular case.
You referred to it as Coppenrath v. Makepeace. Did you mean Currents?
I'm sorry.
Currents v. Makepeace?
Troy Currents versus AD Makepeace. I'm sorry. As to that question as to how, without certiorari review, Mr. Coppenrath would be deprived of his right to pursue justice, there is no other avenue other than appealing this permit to try to get judicial review that compares the requirements of the bylaw to this 2-page permit that was issued for this 4-year operation, 6 days a week with 140 trucks coming in and out of the driveway across the street from his home. It would be an insurmountable bar if someone like Mr. Coppenrath, whose house shakes and whose family cannot have peace and quiet inside their own home due to these operations, as he's testified, and that, again, I would like to emphasize that that testimony is unrebutted. So in their motion to dismiss, Pontiff and the Earth Removal Committee did not submit any kind of evidence showing any fact about this. It was simply a motion to dismiss based on the complaint. In response, Mr. Coppenrath submitted his affidavit. Again, on the reply, neither the Earth Removal Committee nor Pontiff submitted any rebutting affidavit or evidence. So what is before?
Right, so then what the judge said is, because, this is at page 4 of his decision, because of that, the court accept as true the factual allegations in your client's complaint, the affidavit, and the reasonable inferences. So he took those and then decided as a matter of law that your clients lack standing.
Well, we're arguing that he misapplied those facts, that it's illogical to find that the dirt, noise, and vibration are concrete, as he did, which is he found they were not speculative and not hypothetical and therefore concrete. But then to find that despite this personalized affidavit, the court could not figure out how Mr. Coppenrath was harmed. Well, he described specifically in his affidavit how he is harmed. He experiences noise and dust. His family can't sleep. His house shakes. His property is despoiled by the dust that is coming off of the truck traffic going by his house. So if he is not able to pursue judicial review of this permit, indeed, this is an insurmountable bar to anyone in the town of Carver who suffers from what the court admits are concrete injuries. and they are
But
not.
he says, though, in his affidavit, there is dirt and dust all over Tremont Street. Doesn't that cut against his particularized harm?
No, it doesn't, Your Honor, because as the Parisho case states, it's not that no one else in Carver suffers some harm. It's whether this particular individual identifies particularized harm. The cases are such that it doesn't mean that only one person is harmed, but it's the nature and magnitude under the Fisk case. So we have shown by the nature of the harm and the magnitude of the harm that his is different from what is suffered by other residents of Carver.
Your time has expired. Let me just make sure. I see no further questions, so we will have to leave it there. Thank you very much, Attorney Sheehan.
Thank you, Your Honors.
Attorney, is it Rao? Rue, I apologize.
Good morning, Your Honors. I'm Jeffrey Rue from Foley and Lardner on behalf of Appellee E.J. Pontiff Cranberries Incorporated. May it please the Court. I'd like to start by putting some context around this case, geographic context in terms of where the actual earth removal activity is taking place in relation to appellant's residence, and litigation context. Let me start with the geographic context, because I think it's critically important. When you read the briefing here, there's a picture that appellants are trying to create that their residence is directly across the street from an active work zone. The picture is created that you could effectively look out their window and you could see the earth being removed, trucks going back and forth, but that is simply not the reality. I want to direct the Court's attention to the Record Appendix, Volume 1, page 67. This is the site map that shows the farmland that's owned by Pontiff here. This is a parcel of land that's 700 plus acres in size.
And this was in the record before the judge at the motion to dismiss hearing?
It's part of the administrative record that was before the Earth Removal Committee, yes, Your Honor. So this site map shows the 5 separate proposed bogs. There was an existing bog already, and then there's 5 separate proposed bogs that are identified by the green rectangles down at the bottom of the page and going up on the right-hand side. Now, Pontiff is constructing these bogs in order, starting with bog number 1, which actually just completed and is set for inspection this weekend, going to bog 2, 3, and 4, and so forth.
So can you do me a favor?
Yes, Your Honor.
Hold on. Folks, you got to turn your cell phones off. Could you go to Volume 2, page 23, and tell me what that photograph is in relation to the one you just showed us at Volume 1, page 67?
I am sorry, Your Honor, I do not
All
have...
right, so it's figure 19, shows work beginning in 2014, and then typed onto it is, by 2018, the Federal Furnace commercial mining operation had excavated into groundwater at least 3 locations in this area, and then it says location 3, mining underway. I'm trying to figure out how that relates to the diagram you just showed me.
What page you have?
So it's Volume 2, page 12.
Thank you.
And there's a bunch of them. There's 12, 13. I guess what I'm trying to understand, are these just dissected pieces of what you just showed us at 67, but you don't have it?
I don't have the full record right in front of me to be able to look at that page with you, and I'm just not sure exactly what that map is. I know that the full site plan, it's...
Always bring the record.
Yes, Your Honor. The full site plan is on page 67 here. That is the picture that shows the full geographic context, which...
Okay, so on that Volume 167, where is the Coppenrath's house?
So it's off the map, Your Honor. So what's going on here is the Tremont Street is the road that shows, you see the red line, that's the truck entrance. Now, there's a scale on this map. It might be hard to see on thing, but if you use that scale and go to the edge of bog 1, where the closest place where work was being done, that's about 3/4 of a mile as the crow flies. Then you have to turn left on Tremont Street to get to the Coppenrath's residence. Now you see there's a large area of woodlands that borders Tremont Street. That's 500 or so feet in depth there,
Well, let
based
me
on the
ask you, there's
scale.
a red dashed line, and then there's a red dashed line with blue. Which one are you talking about?
The red dashed line that goes to
From the
the,
top down, as we're looking at it, to the left.
it's the bottom left-hand side, yes, Your Honor, that's the red line. There's some alternative truck paths, but that's the main path that goes out to Tremont
I'm with
Street.
you.
And so if you turn left there on Tremont Street, you have to travel another 3/4 of a mile down the road to get to appellant's residence. And appellant's residence is not on Tremont Street, it's on a side street, a cul-de-sac, Crow's Nest Road. Their house faces Crow's Nest Road, so it's the left side of the house that's parallel to Tremont Street. About 250 feet between Tremont Street and their home, and again, it's a heavily wooded area enclosing their home there. Now, Tremont Street itself is a 2-lane highway, 45-mile-an-hour road. It's about 5 miles going down south to hit 495, and about 7 miles from the site entrance to get up to Route 3. So this is the main thoroughway in between those two major roads. It goes right through South Carver. The center of South Carver connects through Main Street, and every one of these trucks leaving this site is either going south to 495 or up to Route 3. So that's the geographic context here of where the work is actually taking place and where appellant's residence is.
Only if it's in the record.
And
Only-
it's
No, my question. Only if this answer is in the record. Did any other abutters challenge the permit? Only if it's in the record.
not to my knowledge, Your Honor.
Not to your knowledge that it's in the record, or not to your knowledge that anyone
Not
else
to
challenged
the knowledge that
it?
there's any challenge, or that there's in the record, since there would not be any challenge. That's the geographic context. The litigation context, we referenced this in the brief, and I'm not going to dwell on it, but I do think it's important to note that appellant's counsel and the advocacy organizations she's founded have filed at least 25 different lawsuits and administrative actions in the last several years against Pontiff, other cranberry growers, construction companies, and municipal bodies, in what's alleged to be this grand conspiracy that these cranberry growing operations are just a ruse to do illegal sand mining activity.
Well, that's not the issue. The issue is whether or not there is standing, so let's confine the argument to that, please.
Yes, Your Honor. So the injuries here that have been raised, the governing case law is very clear, that the standard to establish standing in a certiorari case is formidable. Generalized claims of injury, injury that's speculative, that's insubstantial, and does not flow from the complaint of action does not suffice. So the speculative injuries here have been conceded. The court has noted what those are. The Superior Court was absolutely correct when it said there is nothing to establish that those lists of injuries as set forth in the complaint are actually occurring or might imminently occur. So what we're focused on is really just the dust, the vibrations, and the noise caused by the trucks. Those injuries are insubstantial, conclusory, and generalized. First, there's no dispute here that the permit sets parameters around when activity on the site can take place. This is general working hours during the workday, during the work week, and then an abbreviated schedule of 8:30 to 1 on Saturdays. So
And it's 7 to 5, Monday through Friday?
that's correct, Your Honor. And so the noise that's allegedly waking appellants up and preventing their sleep, that's not happening in the middle of the night. That is happening.
Okay, I mean, a newborn doesn't sleep when we sleep.
That's true, Your Honor. I've had 2 of them, and I know they sleep throughout the day, but they tend not to stay asleep anyways. But what we're talking about is noise that's coming from a highway that is 250 feet away from their house, a major highway that connects 2 major roads. And I would submit that noise, truck noise, from a highway during the daytime.
Tremont Street is the highway?
What's that?
Are you saying Tremont Street is the highway? Or are you
Tremont
talking
Street
about
is a
Route
highway. It's a
3?
2-lane
Okay.
highway. And truck noise during the day on a road like that is simply not the type of substantial injury or injustice giving rise to a certiorari claim.
I don't remember, did the judge go for a view in this case?
Did the judge go for?
View?
I don't believe the judge went for a view of the site. The second thing I want to note is that, as the Superior Court said, the claim that this noise and dust are somehow impacting appellants' general health and welfare is wholly conclusory. There's no record evidence of any medical diagnosis or treatment related to the dust and noise, no explanation of how or in what ways the health of the appellants is actually impacted, and more is required for standing here. Finally, the harm associated with the dust and noise is simply too generalized. As the Superior Court found, nothing in the complaint or the affidavit indicates that these purported harms are any different than what would be experienced by all others abutting or traveling on Tremont Street. Now, appellant's response here in the briefs is essentially to create a straw man and characterize Pontiff's argument as saying that standing is never permissible unless the harm is particularized to just one person, that if anybody else has it, that doesn't work. But that's not our argument. Our argument is that the harm cannot be generalized. It must be particular to a plaintiff, or as the courts often say, it must be different in the nature or magnitude from the general public. Now, courts have not specifically defined who is the general public here or how many people need to be harmed before a harm becomes generalized harm. And as we've noted in our brief, though, the cases where standing is found in a certiorari context have tended to involve harms that are specific to a particular plaintiff. But there are examples where there's more than one plaintiff. I think as the Enos case, the SJC said in Enos, the terms used to address standing, terms like generalized harm or particularized harm, these are elastic concepts that have different meanings for different people. And appellant's suggestion here is that they've shown particularized harm because the truck noise and dust that they're experiencing is not the same as everybody in the town. There are people across town, they're nowhere close to site, they're not experiencing that noise, they're not experiencing those vibrations. Well, that's certainly true, we're not disputing that, but that's not enough to get you particularized standing. That's not what the case law would support, that sort of distinction. Instead, the cases show that—
You made a decision below not to file anything sort of in opposition by way of complaint or affidavit. So the argument is that the judge was supposed to take the complaint and the affidavit as true and in the light most favorable, and as a result, or with reasonable inferences, excuse me, and in doing so, he did not apply sort of the correct legal standard, or based on the uncontested affidavit, there was enough to establish standing. Why is that wrong?
It's wrong because this was a facial challenge to the sufficiency of the allegations in the complaint. The judge accepted the affidavit and found that as a matter of law, those allegations were not enough. This was plaintiff's burden to establish that standing was there to be able to be heard in court, and the injuries as described, as accepted as the way that they were described, were simply not particularized.
What about the averment in the affidavit, paragraph 15? On a nearly daily basis, I observe and hear the earth removal operations and the trucking of sand and gravel at the site starting early in the morning. So that is suggestive of something that this plaintiff sees, hears, and is impacted by, as opposed to just trucks going by on a road.
That noise that is heard from the site can be heard by anybody that is nearby that site within hearing distance. And that is not a particularized, it's not a substantial injury, just hearing noise of a work zone in a work day.
He then goes on to talk about the significant amount of noise. I don't think you want me reading that from the affidavit as well, but go ahead.
But this is not particularized as that concept is based for standing in the case law, because everybody on Tremont Street that's near enough to in earshot will hear that noise. That's just the nature of construction and of earth removal operation. There's going to be noise associated with that. If that's the case, then everybody that lived near an earth removal activity would always have standing because there's noise going on. That's not the type of injury that grants standing in these cases.
So what if it's the exact same affidavit, only he adds in there, and when the excavation starts in the morning, paintings fall off my walls and my dishes crack? Good enough?
I don't know
or if everyone's dishes crack, no harm, no foul.
I don't think that's the case, Your Honor. If there was,
so answer my hypothetical. Would that be sufficient?
it could potentially be sufficient if there was that level of harm that the house was shaking so much like an earthquake and things were falling off the wall.
I didn't say like an earthquake. I said such that paintings fell off my walls, or my corkboard fell off my wall, and my glasses crack.
If that level of harm was experienced based on the noise that was being created, that may well be particularized enough, Your Honor. That's clearly not in this record, and that hypothetical seems unlikely to me to comport with reality here. I think that the case law is clear. We cited the Fisk case. I do think that really controls the outcome here. It's the same type of harm that's occurring in that case.
Last question for me. What's your very best case that under these facts, the averment is insufficient to create standing? Your best SJC or appeals court published case?
Fisk is the best case, Your Honor. Fisk is the best case. It's too close and similar in time. And again, we're
Agree on one thing. That's excellent.
Thank you, Your Honor. Thank you.
Thank you very much. Case is under advisement. Very well done, counsel.
Thank you.
Our next case, and then we will be taking the morning recess after this one, is the HAMPDEN-WILBRAHAM Regional School District and others versus the Massachusetts Interscholastic Athletic Association, docket number 24P1432. See, I would have guessed all those people were here for the school case, but they were here for the Cranberry case. I was wrong. We're not splitting time, right? You have counsel sitting with you, but each of you is, okay.
We are not splitting time, Your Honor.
Perfect. Attorney Hodge, when you're ready.
May it please the court, my name is Kay Hodge, and with my colleague, John Simon, we represent the Massachusetts Interscholastic Athletic Association, otherwise known as the MIAA. This case raises a number of important issues, and it deals with 4 consolidated cases in which an injunction was issued in each of the cases. They arise out of the same sort of
Could I
set
ask
of
you a
facts.
preliminary question, though?
Sure.
So it's 2 parts, so I'm not trying to trick you. Aren't the claims before us moot? And then if you agree that they're moot, I know you're going to tell me that they're capable of repetition yet evading review. So, and that we should decide it. Are you prepared to concede that the current claims are moot?
I'm sorry, I didn't
Are the
hear-
current claims moot?
No.
Why?
Because there is a provision that makes clear in the rules themselves that if we are successful, as I hope we will be, in overturning these injunctions, then the plaintiff schools would owe us attorney's fees.
So that section, is it 29.13, I think?
I believe, Your Honor, I could,
No, it's in there. I'm pretty sure I have that section right. So let me ask you this question. So you're saying the basis for attorney's fees is that provision in the MIAA handbook, correct?
oh yes, it's
Okay.
not otherwise, it's not in statute or anything.
Okay, so here's my question. You agree that Massachusetts follows the American rule for payment of attorney's fees, yes?
Yes.
Which is typically you pay your own fees.
Yes.
I'm aware of 4 exceptions to that. One is fees paid as sanctions, which is not this case.
Right.
2 is 231-6F for frivolous appeals. There's also a rule that has the same thing. I don't see that as this case. 3 is statutory, and you're not alleging that there's any payment of fees due under statute. And the 4th is contractual, that it's agreed upon by the parties. So you're relying on that 4th exception, correct?
I'm relying on the fact that members have imposed upon themselves and each other the obligation to avoid suing each other. I mean, that's really the basis of all of this.
So of the 4 categories,
It's contractual.
it's contractual.
It's in the nature
How do
of
you
the
reconcile that? And I don't mean to interrupt you, but how do you reconcile that with your argument that there is no contract here?
Well, Your Honor, I think that at base, what you have is you do not have the elements in the complaint, and typically the complaint should have elements of what the contract is. Here, normally it is of the bylaw provision, or there is another provision of some kind. What is here, clearly, you join the MIAA, MIAA accepts your dues, but in exchange, we agree to sponsor and to facilitate athletic competitions among students.
In exchange for payment.
In exchange for payment, no question about it. And
Go
we
ahead.
agree to enforce the rules that are created by the membership. And one of those rules, and I think that's where the nub of this case is, and that is, this case is about deadlines. This case is about what you have to supply and when you have to supply it and the consequences if you don't. Here,
I understand that. I don't mean to interrupt you, but well, maybe I do mean to interrupt you.
you have
So-
every right to interrupt me, so I accept it.
Well, thank you. Before you keep going with your argument, I'm having a great deal of trouble reconciling the notion that this case is not moot because you may be entitled to fees on a contractual basis, and you also making the argument, but there's no contract here, or at least they don't allege there's a contract here. I mean, I've gone through their complaint, and it seems to me it's there.
Your Honor, I do make, it's an argument in the alternative in our brief, and I make that argument standing here before you at this moment, that even assuming there is a contract, the fact of the matter is that there hasn't been a breach. We have done what we said we would do. We have provided athletic contests. That's what this is all about. It is about the athletic contests and where people sit and where they're seated or they're power ranked in those contests.
Understood.
And the question is, and quite frankly, if, let us just say, they decided to sue us, it was, let's just take it, it was in certiorari. So there wasn't even a contract argument being made. We wouldn't necessarily, as the MIAA, argue, we could appeal that issue. But in following the appeal, if we were successful, we could bring our own contract claim based upon the rule. But we're not doing that. That's not what we're attempting to do here. We're only saying, and I believe that Chief Justice Blake has it correctly, we do argue in our brief and we argue here that as in Abner A, this is a situation which is likely to be repeated. I will only tell you that this year alone, out of my own personal experience, I have in fact already had to defend several cases which deal with deadlines and information that is provided, or MIA has a rule that says you gotta do X by Y, and someone doesn't do X by Y. They don't list a particular student or athlete for a particular contest.
Is there any dispute that the MIAA could amend its handbook to add in this TBA, TBD requirement?
No, I don't dispute that you could do that. Again, my argument would be to you, Your Honor, is that the courts should not be the ones telling MIAA what needs to be in the book or not.
We agree with that.
Let me also say this, and I will say it. The truth of the matter is there is no dispute. Everyone understood generally what the rule was. And I would point, Your Honor, specifically, very specifically, to the record appendix, and in particular, it starts at 274 to 275. It is an email, which is extensive, from the principal of Minnechaug High School.
Right, where he says basically, hey, we screwed up, we missed the deadline.
That's what he
But
says.
then he also says, but you're being wicked unfair, and I don't like the way you're handling this, and it's unfair to everyone.
You know what? And I understand. He may think it is unfair, but he understands that A, there was a deadline, B, they didn't comply, C, that the consequence he could have, and he says it very explicitly in his email, he says that the MIAA clearly state we can only play games on our schedule, and that he wasn't required to play the game. He could have asked PVIAC for an exemption. Keep in mind, we're in this world in which MIAA is the statewide authority, but the league operates its competitive activities so that their schools and their players will qualify for the MIAA statewide tournament. And so they try to build on each other. In this instance, if you read the context of this email, the email is really more upset at PVIAC than it is at MIAA. But be that as it may, I do believe that at bottom, the question really is, what evidence existed in the record regarding these deadlines and regarding the obligations, TBD or TBA, that one can discern whether or not it needed to be in a rule? I understand that the Superior
Why
Court
did
judge—
16 of 49 schools miss it? Sorry, why did 16 of 49 schools make the same mistake?
If I could correct you, Your Honor, there's no evidence it was only 49. The circumstance is this. It was 16 schools. 4 of them happened to be controlled by the same athletic director, so
Okay.
just to let you know, 4 of them. That those particular schools out of 59 were the ones
59, sorry.
in western Massachusetts, but they were a part of a larger set of schools that includes the entire state. So there were 160 schools that ran the 3 kinds of competitive activities that we're talking about here. It happened to be soccer, field hockey, and volleyball.
Did the other parts of the state also have regional tournaments?
Yes, they did. Some of them did and some of them did not. Others had Turkey Day tournaments and others had different kinds of tournaments.
Did schools in other parts of the state also have schools that failed to comply with the TBD, TBA requirement?
In this instance, no. Your Honor, let me just say this. The record doesn't reflect that any of them did not comply. I will say that the record does not— MIA's position is we have uniformly applied this rule. And I understand that all rules at the end of the day feel to the person on whom it's being applied negatively to be unfair. I also understand the circumstance of the Superior Court judges. They were being faced with a request for a temporary restraining order, preliminary injunction, on the day of the particular athletic contest.
So let me ask you 2 questions that maybe go more to substance than to the question of mootness. The first is, and I'll ask them at the same time and decide how you want to handle it. Is the forfeiture penalty arbitrary and capricious? That's my first question. And my second question is, whether we affirm or reverse, what happens next in the Superior Court? Because this is a PI. There's still an underlying suit. So what happens next? Those are my 2 questions.
Well, I don't believe that an agreed-upon penalty for failing to do something is necessary, or for doing something, is necessary, arbitrary, and capricious. Let me be very, very clear.
Agreed upon by whom?
Well, let me just say, by all the members. Let me just say this.
Because the school districts join the MIAA?
School districts make the rules. If you read the documents in the plaintiff's proffer, they include the amendment process for rules and what goes on. And let me just say this. The reason why we have what's called the sports limitation sheet, and it is attached to Rule, I believe, 35, and it says, and there's a hyperlink to the sports limit, and it's a long list of all of the different deadlines and what you have to do by those dates. Does it get to the detail of TBD, TBA? No, it does not. But it was explained in the documents that are attached to Sherry Bryan's affidavit, which were a part of the executive director's missives out to the entire 385-member membership of the MIAA. So to answer your question, Chief Justice Blake, the fact of the matter is the forfeiture was attached because, not because they didn't put TBD, TBA on their schedule. It just meant failure to have included that on the schedule meant it was not there. The consequence was you were not supposed to play games that were not on your schedule. They had the choice to play it or not. The circumstance here is a little more fulsome or more
Well, I mean,
confusing.
part of their response is going to be, number one, the MIAA knew about these regional tournaments, and so did everybody. This was no big secret. And number two, you're not alleging that, I mean, the whole purpose of these rules is to ensure that no one's gaming the system here, and no one's making that claim here.
Your Honor, the fact of the matter is rules are created for a reason. So suddenly you're going to put MIA in the position of saying, well, was that gaming the system or was it not gaming the system? And if it was, then obviously I do this, or if it wasn't. But let me complete my thought. The thought is that it wasn't the TBD, TBA. It was that they played a game after it was not on their schedule that they played the game. What the principal is admitting in his email is that he understood he had the choice of playing or not playing the game. And they chose nevertheless to play a game that was not on their schedule. And why is that important? It is important because when the PVIAC said, we will arrange with the MIAA to allow you to play these games, but as the principal admits, the usual forfeiture penalty will attach because you will be playing a game that's not on your schedule. And while the purpose of the rule is not there to just be vexatious and make out rules, you know, on particular days you've got to wear a particular color, but rather that there was a reason. Does the reason attach to absolutely everything? No, but keep in mind, in this instance, it may have been, 16 schools.
Your time has expired.
I'd
but-
like you to answer the
but I
second
wanna
part of
ask
my
Justice
question.
Blake's question, yes.
So we affirm, we reverse, whatever we do, what's left to happen in the Superior Court in the underlying litigation?
I think that if you, assuming for a moment you were agreeable, you agree with me, that deadlines are not arbitrary and capricious, and applying rules that set forth a punishment for doing something that's admitted is not arbitrary and capricious, then the fact of the matter is that from MIA's point of view, we will wait to see what happens. Obviously, there can be a further appeal. Obviously,
Well,
there could
no,
be...
but what happens below? Are we back to the issue of attorney's fees? What would be left to litigate below?
There probably would not be anything left to litigate out of this particular case, unless, should a determination be made, and it's a separate determination from my point of view, of whether or not the MIA Board of Directors wishes to proceed with attorney's fees, they can do so. In my experience, we have proceeded by sending letters in the past, and we have not had any issues that has resolved itself. But I just don't know.
Let me check with the panel. I don't see any other questions, so we will have to leave it there, Attorney Hodge. Thank you.
And I thank you very much. MIA asks that you obviously dissolve the injunctions in this case and make a finding about whether or not the various actions here were arbitrary and capricious. Thank you.
And Attorney Zuckerman, if you need additional time, we gave Attorney Hodge 2 additional minutes. I will certainly give those to you.
Thank you, Chief Justice. Good morning, Chief Justice, members of the panel. May it please the court. My name is Elizabeth Zuckerman. I represent plaintiffs' appellees who are Bay State Academy Charter Public School, Pioneer Valley Regional School District, the Northampton Public Schools, and the individual student athletes from the towns of Hampden, Wilbraham, and Munson. And with me is Jonathan Atwater on behalf of the Hampden-Wilbraham Regional School District. Your Honors, leaving aside for a moment that this dispute is moot.
Are the parents, I'm sorry, are the parents plaintiffs?
In the instances in which the children are minors, they are, Your Honor, as next
As next friend, okay, but not as individual?
That's correct,
Okay,
Your Honor.
sorry, thank you.
I have a preliminary question as well. Are you aware of any precedent for bringing a claim against the MIAA as a breach of contract claim?
Your Honor, I believe that in some of the underlying eligibility, athlete eligibility claims, there has been an underlying breach of contract, but as I stand here, I can't tell you that for certain. I'm thinking of Abner A., but I cannot remember whether that was brought in the...
Abner A. was a cert claim. I
was a
don't know
cert
if there
claim.
was also additionally a contract. The reason I ask is I've always seen these brought as cert claims. I've never seen one brought as a breach of contract claim.
Your Honor, the breach of contract issue has been interesting because below there were two arguments that I found curious. The first was that there is no contract, and the second was that if there is a contract, the student athletes are not the intended beneficiaries thereof. And I raised the question in the lower court, and I would raise it again. If they are not, what is the purpose of this organization, which explicitly is set up to regulate and manage athletics for interscholastic high school competition? So, Your Honor, I believe contract action is an appropriate means by which to bring this action, because I believe there is a contract between the member schools and the MIAA, and the MIAA is breaching it by dealing in an arbitrary and capricious manner with the
So
intended
why,
beneficiaries.
tell us with great particularity, what was arbitrary and capricious about their determination here?
Yes, Your Honor, thank you.
They being the MIAA.
Initially, Your Honor, it is the fact that this is an unwritten rule. As my counsel stated, there is no ability to point in the handbook, which is quite lengthy and quite detailed, to any provision which
With
says...
the number of complaints and issues and things that come up that the MIAA has to deal with every day, it would be impossible. That handbook would have to be 30,000 pages long, and they would still deal with complaints and issues and punishments and all sorts of things that are outside the scope of the handbook. So I find that to be incredibly unpersuasive.
I agree that they could not account for everything,
Let me
Your
say
Honor.
unpersuasive, not incredibly. Adverbs are for the weak. I was
it is-
taught by my 8th grade teacher, so go ahead.
So one of the hallmarks of an arbitrary decision is that it's not, that the policy being enforced here is not written. Many other policies were written, this was not. The second, Your Honor, is this policy was unrelated rationally to the offense. The offense, as it were, was committed by adults who were charged with submitting schedules. The student athletes were not permitted to submit schedules. It's not their role. They had to be represented per the written rule by the adults.
What about all of those emails and everything that's in the record where the athletic directors and the principals and everyone at the schools was reminded 2, 3, 6 times, hey, don't forget about the regional tournaments or other games, and if you're not sure, put TBD or TBA.
Your Honor hit on this earlier when you mentioned that of the Western Massachusetts schools, there were 16 who failed to comply with the TBD requirement. Your Honor, the factual context here, and this was in the record, was that this was a relatively new policy which arose after there had been a change in how regional tournaments and state championships were run. So I believe it was 2021 that this had come into play, and it was not being enforced until the season in question, or at least the year in question, 2024.
Are you aware of any schools that have failed to comply with the TBA tournament requirement or that requirement after this event?
I am not
prior
aware, Your
seasons?
Honor. No. I imagine that after this event, there will be greater compliance. Certainly, this brought the policy to the forefront. Your Honor, to go back a little bit to my earlier point about the nature of the sanction, not only is it imposed on the students rather than their adult representatives who are responsible for the error, Your Honor, it's incapable of even application. What MIA did here is said if you play these games, which we can talk further about the fact that they were required by PVIAC to play these games, if you play these games, you will receive a forfeit loss, 3-0, no matter what the outcome of the game is. Okay, but unless you play another team that also messed up their schedule submission. In that case, which you have no control over that, of course, the team or the athletic director, if you happen to be matched against such a team, you will not receive a forfeit loss. You'll receive a draw. It'll be as if this never occurred.
Saw the helpful chart in the record.
Yes. So, Your Honor, there was baked into this schema of punishment was the fact that it could not be evenly applied because it depended on who a team drew as an opponent and how that team fared, not athletically, but on a schedule submission.
Under the MIAA proposed punishment, would any teams that were in the tournament now be disqualified from being in the tournament?
I believe, Your Honor, that the record reflects that that did not occur, but that it was hypothetically possible.
My understanding is that the record reflects that any team that was in was still in, and any team that was out did not get in.
That's my understanding, Your Honor.
So it just affected seedings. And I know you're going to tell me, because I read it in the record, that, well, seedings are big, it affects who's home and who's away, and revenues to the school and all that sort of stuff.
Well, and correct, Your Honor, because that's actually been MIAA's argument, is that these other teams which submitted correct submissions with TBA or TBD, that they were prejudiced.
But usually we're trying to preserve the status quo. And here, no matter which way we go, teams are affected, both the, let's call them the misfeasance, and the teams who had nothing to do with this.
That's correct, Your Honor.
So the status quo, either way, is going to be impacted,
But
which makes this
ultimately,
sort of a difficult case.
I think the difference, Your Honor, is that by the injunction issuing, the teams were recorded for their actual performance. What MIAA Core is arguing is we should be able to impose a sanction that effectively rewrites what actually occurred. We should get to record fictive results because there are adults that didn't follow our submission rules, and that is a penalty we're going to impose that ultimately falls upon our student athletes, the people we intend to serve. Your Honor, that in and of itself is arbitrary and capricious. The penalty isn't related to the offense, and the penalty falls upon the wrong people. The MIA had an option to say, schools who messed this up, pay a fine. It's a membership organization. You pay to belong. You've caused us more administrative hassle. Pay a fine. There were, and the record reflects, several weeks during which this could have been worked out before it came to the crisis point that it became, where these games were, as counsel repeatedly referred to, about to be played, and the judges had to make a decision at the trial court level.
Could you tell us, again, with specificity, what is the exact breach that occurred here?
The breach is that they're not reasonably administering a system of interscholastic play. They have a rule book, but instead are subjecting the members of the organization and the students those members represent to unreasonable, arbitrary decision-making.
What specific provision of the contract, as you call it, or of the handbook is being breached here, or was breached?
Your Honor, it goes right back to the requirement that the membership abide by the rules. I would say that has to be a bilateral.
What specific section of the handbook was breached?
Your Honor, I believe that rule is Rule 30. I may have that incorrect. It may be 29. Let's just check for a moment. Excuse me, it's Rule, I have it wrong. It is Rule
35 or 36?
It has Rule 32.1, Your Honor.
32.1, thank you.
Which requires that the members understand the rules. Your Honor, I would say that has to implicitly include that the rules will be enforced, and that by implication that there won't be rules added that the membership could not be aware of. The membership did not have an awareness that this would be the penalty, a forfeiture penalty, which is designed for when you play ineligible athletes or when there is student misbehavior connected with athletics, that penalty would apply if there was a paperwork problem on the part of adults acting on behalf of their teams. These student athletes were treated unfairly because the other partner to the contract, MIAA, wasn't following and enforcing its rules.
Any violation is going, it's not as if the student is out there answering emails from the MIAA. So no matter what, it's going to be done by a representative.
Yes, Your Honor.
And if the mistake is egregious enough, the MIAA has to be able to act or react. Otherwise, their rules are frivolous.
I would challenge that, Your Honor, as there are offenses which can be committed by the students which render teams ineligible. If a student who is not eligible to play is played, that's a decision in which the student participated.
Abner A and a whole different ball of wax.
Exactly, but that is a situation in which the student or these students as a group had a hand in participating in the offense. Here, not only didn't the students have a hand in the mistake or the erroneous submission, but they're not permitted to make the submission. They
But
couldn't have done this
isn't
right.
part of the point of the overscheduling rule to protect students from having coaches that, make them play a game every day and their schoolwork suffers?
I believe so, Your Honor.
So,
And
so
this-
why isn't the appropriate remedy what's said in 34.6? Any school overscheduling must forfeit.
Because, Your Honor, this is not the meaning of overscheduling as it's used in that rule. As it's used in that rule, and as it continues into the next rule, there are discussions of caps on how many contests can be played in a given season, and they vary per sport, and it continues through Rule 35. But, Your Honor, these weren't over cap. These simply were, we didn't write them on the list. And the record reflects that those teams or athletic directors making the mistake to not put them on the list did so because the list said, list all your in-season games, including tournaments. And given the history here with this regional tournament and the state championships and the changes that had occurred, a certain percentage, almost a third of the affected athletic directors, did not understand that this was an in-season tournament game. So they didn't put it on the schedule. That's what it comes down to, Your Honor, is a question of how an unclear policy, expressed in emails, not written in the handbook, was interpreted. And although there were several weeks during which this could have been worked out with minimal administrative burden to MIA and zero competitive advantage on behalf of the schools and the students that were playing, MIA said, absolutely not. We're going to subject you to an unwritten penalty, which is forfeiture. We use it in other cases. We're going to use it for this.
I have two questions that are on a somewhat different topic. The first is, I understand why you claim this current case is moot, but I'd like to know why you think we shouldn't decide it anyway as capable of repetition yet evading review. And then secondly, no matter what we do here, what's left to do in the Superior Court?
Thank you. Your Honor, in this instance, it's not capable of repetition but evading review because it's intensely fact-specific. We have a policy that's unwritten that the MIA has indicated is going to be written. We have a situation in which this was newly enforced. That's been acknowledged. This was a relatively new tournament and state championship structure within the last few years. And all of these factors are really what led to this particular set of circumstances. It is highly unlikely that this particular set of circumstances could arise again. And so—
How do you reconcile that with the fact that you allege that 27% of schools didn't or couldn't follow that directive? I mean, you argued below that this was an ambiguous, tough-to-follow instruction, and now you're telling us, well, but it's not going to happen again. If it was difficult then, it's probably going to come up again.
I think the parties have been made aware, Your Honor, that at least as to these factual circumstances, it's not going to arise again because this, frankly—
But it's not just these parties that we're concerned of when we're looking at the capable of repetition but evading review standard. We're looking at all of the members of the MIAA.
And I think the record reflects, Your Honor, that this has been discussed within the MIA, which, of course, is a member organization, quite extensively. And at this point, there has been feedback to the membership regarding this specific issue.
Statewide?
I believe so. Because, again, it is a member organization. So the rulemaking, which, again, we contend this wasn't a rule, this was an unwritten policy, but the rulemaking has involves the membership, and they've been made aware of this issue.
And so what's left to do?
Your Honor, there's the ideal answer and there's a real-world answer. The ideal answer is that this would be litigated to its conclusion because it is a breach of contract to deal in this manner
So
with
if
the
we
schools.
affirm, so you're successful on the PI, you're not dismissing your suit?
Your Honor, it's going to depend ultimately on the ability of what are public schools to continue to participate in litigation against their membership organization. They're limited in that regard. So unfortunately, there's a real-world constraint due to these being public schools on what they might do to deal with an organization that they contend repeatedly treats them unfairly.
And what's the other answer, the non-real-world answer?
The non-real-world answer is that it would that we would take this to its conclusion and cause
On a breach of
MIAA
contract claim?
Yes.
And what is your view on, if you are not successful, Attorney Hodges' position as to attorney's fees?
Your Honor, I think it's this is essentially an unenforceable provision of this contract. I mean, MIA is contradicting itself over whether or not this is a contract, whether these rules apply to it. I think that, and ultimately also the question of fundamental fairness. This is a membership organization of public schools who are asked to pay money for this. There is no alternative. And they are being told, if you challenge us, we will charge you our attorney's fees to be challenged.
Let me just check with the panel. I don't see any other questions, so we'll have to leave it there. Counsel, very well briefed, very well argued, difficult case. It is now under advisement. We are going to take a brief morning recess. We'll be back in about 10 minutes. The next case that we'll hear after the break is RESI LLC.
All right.
Okay. Our next case is, I hope I'm saying this right, RESI LLC, RESI, versus Wareham, Conservation Commission, docket number 25P3. Counsel, when you're ready.
Good morning, Your Honors. Kim Croa for RESI LLC. And just a note, RESI is in a special receivership. There was a special receiver appointed out of Rhode Island and then in Massachusetts. So I'm here on behalf of the special receiver. Still the same LLC, I just pointed out.
Does your appearance reflect that? I just want to make sure we cross the Ts and dot the Is. Maybe check with the clerk's office to make sure if there's something else that you need to file to reflect that, we should do that.
I'll check down there on the way
Okay.
out. Thank you, Your Honor. We are here on appeal. My client, RESI, had filed a notice of intent to build a pier in Wareham in land containing shellfish. The pier was proposed to be located between two existing piers, one of which is significantly longer. The Conservation Commission denied under both the state Wetland Protection Act and associated regulations and the local bylaw.
So I know you know this question's coming, but did your client submit information to the Conservation Commission in the NOI detailing the proposed number, type, and style of the proposed watercraft to be used at the site?
They did not, Your Honor. The question...
Isn't that a problem?
Based on the way that the commission denied the application, no, I don't believe that it is a problem. And I should say the way that they denied it and the subsequent superseding order. And that question really has two parts of an answer. The first part being that there wasn't any specific mention in the decision about how that precise lack of information was the reason for the denial. The local denial was based on two aspects, one of them being this significant shellfish habitat, and the second one being sort of a catch-all provision where it talks about cumulative effects. And inside that provision, it does include the language that one of the factors for denial could be lack of sufficient information, but that concept was raised and discussed during the local hearings, but it wasn't the reason that the local commission gave for its denial. And the second reason why it's not determinative in this appeal is that the local bylaws that are in the record and that were, of course, what the commission decided on, talks about the information on the boats being related to turbidity or basically drawing up the dirt and disturbing the shellfish. And that concern goes precisely to the fact that this is land containing shellfish, which is a state protected resource area. And DEP took a look at the application because after it was denied on the state and the local level, RESI filed a request for superseding order with DEP, and DEP approved the project. So DEP found that the project met the performance standards regardless of the lack of information on the boats. The pier is only...
Does the statute require the similar disclosure of number and size of watercraft?
No, there's nothing in the regulations.
So can't that be interpreted as a more stringent requirement?
Typically, Your Honor, the procedural aspects are not necessarily more stringent. It's how they're used. So if there was a portion of the bylaw that said you can't have a boat that's X amount of feet in this particular area, that might be something more, but the bylaws tie the information about the boats to the land containing shellfish, which is a state resource area. So,
but why doesn't Part A of that Section 16 of the bylaws, it talks about turbidity and all of that, why doesn't that amount to a more stringent bylaw than what was at issue, say, the Quincy bylaw in the Long Island Bridge case? And why couldn't the Conservation Commission decide that the meaning of the cumulativeness and the significance of the effects is what's in that's Part A, and that therefore there's the, sorry, it's a very long-winded question, that the adjacent land is affected in addition to the specific area that the DEP is considering.
That view of the argument is similar to the Fafard case, the 1996 case, that the local bylaw had a 25-foot no disturb, and the commission denied the application saying, well, okay, the application did not disturb within the 25 feet, but it was pretty close, and so we think that probably by being pretty close, it was going to disturb that 25-foot no disturb, even though clearly it wasn't. And so here, the local bylaw did take certain actions to protect shellfish in a way that was different than the state regulations did. The bylaws included in there that piers cannot be constructed in a location that's a significant shellfish area, which is a defined term under the bylaw. And it's defined as being something different than land containing shellfish.
So can I ask you maybe a more fundamental question? Do you dispute, this is at record 169, the commission found, and I want to quote it, that it would result in the permanent loss of approximately 28 square feet of significant shellfish habitat and potentially shellfish as well due to the pile installation. Do you contest that finding?
Yes, Your Honor, and not only do I contest it, but the DEP disagreed with it also. And the DEP, in their superseding order, at record page 203, specifically noted that the conservation point denied the application for permanent impacts, and DEP said, under our performance standards, we have an assumption that shellfish come back after the dock is put in place, and so it's actually a temporary impact.
So the DEP says there that the temporary impact meets the performance standards. It assumes the area will be returned substantially to its former productivity as long as the conditions outlined in the DMF letter and the DEP superseding orders of condition are met. So then when the judge below allows the commission's motion for judgment on the pleadings, he says that you conceded that the project was located in a significant shellfish habitat, and that creates a local requirement for more stringent protections for the resource area land containing shellfish, and that your contention that this, and then he rejected your contention about the more stringent local protection. So is that an error of law? Is that an erroneous fact finding? What did the judge do wrong?
The first part of that answer is that I don't read the judge's decision the same way, but I guess I'd start with that on the de novo review of the record, this court can essentially disregard whatever the trial court found. As far as
can we disregard what the commission found?
No, the commission has an abuse of discretion standard of review at this court, most certainly. But incorrect interpretations of clearly defined terms within their bylaw are not typically allowed the deference.
So for our purposes, it doesn't matter that the Superior Court judge concluded that the project is in a significant shellfish habitat? Doesn't
Correct.
matter.
It doesn't matter because he was making that determination based on the same record that's before this court, which is the certiorari record on appeal.
In the layers.
And then as far as the language that Your Honor was just citing in the decision, we conceded below that this was land containing shellfish. Definitely did not concede that this was a significant shellfish area because the local bylaws say they define significant shellfish habitat in two parts. One, that it's mapped for shellfish, and the other part that it's been designated as significant by either the constable, the shellfish constable, or DMF. And both constable and DMF took a look at this project, and they both advised the commission that this was an approvable project with conditions. Neither of them found that the area where the pier was located was a significant shellfish habitat, as that phrase is defined in the bylaw. The bylaw talks about how, the DMF letter says all land containing shellfish is significant, and it is a resource area under the Act. But that's different. If the local commission wanted to say no piers can be built in land containing shellfish, they could have done that, but they didn't. They didn't use that phrase. They used the phrase significant shellfish habitat, and they created definitions within as to what that means. And the area where this pier was proposed is simply not in one of those areas. And so the argument that we have here on appeal is really two-part. Number one, that that the commission didn't actually rely on a more stringent part of the bylaw. And so therefore, the DEP's superseding order preempts the local decision in full, because
This project would service 7 homes?
the subdivision, there was a subdivision plan that was proposed at 7 homes. It's not part of the DEP's record. If it was the DEP's decision that became the one that was alive, there's nothing in there for the amount of homes.
The project proposal from RESI contains that, and that's part of the record.
That's correct, yes.
So in other words, part of your argument is, and I understand our review's de novo, so take this question knowing that I understand that. But here's my question. Is the essence of your argument, the first part of your argument, that although the judge at the motion stage may have relied on a more stringent bylaw, you're saying that the Concom did not? Is that a fair summary of that part of your argument?
I would say that's a fair summary. I think the trial judge relied more on the boats, that I would say is not really a more stringent part of the bylaw as it's applied to the reasons for decision.
Why is that not more stringent? I'm not following that.
So there's nothing, their request for the
And let me give you a little bit more context. I mean, that's a requirement of the bylaw. You have to disclose that. Your client did not. I don't know if that's because he didn't want to put any limitations on potential buyers who want to have big boats in the water, right? But he didn't comply with that. And there is this concern that huge yachts, giant boats could obviously create more, and I'm going to use incorrect nomenclature, but create more disturbance to the shellfish and to the habitat or what have you. So it seems to be a valid concern. It seems to be a bylaw requirement. So what am I missing?
Well, if the commission was truly concerned with that, they could have created a condition on the size of the boats or the type of the boats that could go on the dock.
But can't they also say, and I understand your view is they didn't say this, can't they also say, look, our bylaw says, tell us X, Y, and Z. You didn't provide that. Too bad. They have that power, I believe.
Well, the Wetlands Protection Act says, which of course is a state, says that the commission should default to conditioning. So they should only deny if it truly cannot be approved. And then if we look at the local bylaw says that they can deny for insufficient information, but that wasn't where it came down to. I mean, RESI could have said that they were going to have 7 rowboats out there. And then unless there was a condition in the order of conditions, 6 months later, they could have said, oh, one of the owners swapped out their rowboat for a powerboat. So any decision, regardless of the information that could have been presented to the commission, it's still, if it was something that was truly important to them, would have needed to be a condition that carries forward, because a boat is not a permanent structure. And that was, the minutes are not on the record, but that was the discussion, that the houses haven't been built yet. They have no idea what boats are going to be out there, so they just can't give that information. But it's the same as if you look like.
But how, if they can't give the information, RESI, how can the Conservation Commission give the information? They might not care if there's 7 20-foot Boston whalers or one enormous yacht. But it's up to the developer to figure out how they're going to market the subdivision.
Otherwise, what's the point of the bylaw?
Right. Well, at the end, the pier had limitation. I'm sorry, the bylaw had limitations on the pier that it couldn't be more than 200 feet from the mean high water. This was 156 feet. I mean, at the end of the day, there's only so much space that could be on there, and the DEP didn't have an issue with it. The question about the boats came down to the effect on the land-containing shellfish, which that particular impact was preempted by state law under Boston v. Quincy. The portions of the combined decision that are based on state law are preempted. So yes, the local decision continues, but that question goes to the state resource area, and that particular conclusion was preempted by the superseding order. Unless there's any other questions, I'm down to the end of the time. Thank you.
Don't see any. Thank you so much. Attorney Bowen.
Good morning, Your Honors. May it please the Court. Richard Bowen, Wareham Town Council. In the 35 or 36 years I've been appearing before this Court, I've always wanted to give a Rod Serling opening to my argument. And so this may be my last opportunity. So imagine a world where you're building a bus station. You have the building itself, and then you have to build the driveways around the bus station. Because a bus station by itself, the building, is useless if the buses can't access it, park. Parking spaces have to be big enough. Now, with that Rod Serling opening, think about a dock. You have a project area. You are going to build a dock. You're going to drive piles into the bottom. You're going to put a bunch of planks, superstructure across the dock. And at that point, are you done with the dock? Well, no, not really. Because the dock as a structure is there to serve a particular purpose, which is to allow the mooring of boats for people to use those boats, and those boats are situated on land that is adjacent to the dock. Just as at a bus station, you have the bus building, where you wait, you buy your ticket, you get your coffee, and you walk out to the adjacent area, and you get on the bus, and away it goes, diesel fumes and all. So when my sister argues that DEP looked at this and issued a superseding order of conditions, factually 100% accurate. What DEP did not look at was the adjacent area. We have the letter from DMF that says that the adjacent area was mapped as a shellfish resource. And it is in that adjacent area that the boats that will use this dock will travel, just as the buses at the bus station will park on the asphalt and drive in and out of the driveway.
So what is the adjacent area? So if you're describing the area to me, what part is the adjacent area?
Everything that is not part of the dock structure.
So everything in the waterway coming up to the dock is the adjacent area, essentially?
Well, I think there's a limit to that. I would not want to suggest that the channel that accesses the dock would be part of the adjacent area. But imagine this is the dock right here. We're going to put a boat there, a boat there, a boat there. That, at least, is the adjacent area.
So the DEP looked really only at the structure, not the ingress and egress to the structure?
Correct, Your Honor. DEP looked at this. DEP did not look at that.
And is their standard more or less stringent than the Conservation Commission?
With respect to the adjacent area, they have no standard. And that, I think, is where the case turns.
Okay.
Now, I will admit that were I writing this decision, I mean, not your decision, but the commission decision, I probably would have said, order of conditions denied, failure to submit application, we need not pass judgment on the remainder of the application. That's probably where I would have stopped, only because if the application is incomplete, and you can't properly evaluate the effect on the mapped shellfish area, as DMF described it, the adjacent area, how can you properly evaluate the application? So
skipping forward, does it matter then what the trial court judge said about the shellfish area as it relates to the Conservation Commission versus the DEP? Does that matter to us at all?
I don't know that it does.
Okay.
Judge Pasquale was a wonderful judge. I sat, I don't know if I'm supposed to say things like this, but, I sat and puzzled over it a bit and tried to figure out, where the whole thing was coming from. And at the end of doing that, because I credit him with more intelligence than I think I have, I think I decided that in a different sort of way, he was trying to describe the difference between the structure and the adjacent area. He comes to that result in I think, a somewhat different way than I do. But I think the net result is the same. If you do not provide the information, you cannot judge the totality of the application. I mean, if you're just building a dock, great. Maybe DEP is right. Maybe they're right. Maybe it's just a temporary problem. I mean, my client would disagree, but maybe they're right. And let's just say that the Quincy case requires you to defer to their finding on that. DEP did not arrive at what may be the most important part of the decision. We have a mapped resource area. We have insufficient information. And why is this important? If we were talking, as my sister said, something about rowboats, yeah, I'm okay, rowboats, probably fine. People are going to dock their O'Day sailboats or their 110s or whatever they're going to do, probably fine. But if somebody's bringing in a cigarette boat or something with 3 Evinrude outboard motors on it, you're going to have a little problem called prop scouring, and you're just going to scour the bottom with fairly high-powered motors.
So that's a nice segue to my question, which is, did the motion judge here rely on a basis that the Conservation Commission did not specify in its decision? More specifically, the judge wrote, and I'm paraphrasing, but he basically wrote, in part, that the applicant failed to comply with the bylaw provision requiring them to disclose the size and number of watercraft. And that's a problem. Did the Conservation Commission rely on that same bylaw in its denial?
I believe they did, Your Honor.
Where can I find that? Because I don't see that.
I'm reading right from...
What page are you at in the record appendix?
Oh, Ash, I'm mindful of the Chief Justice's admonition about bringing the record. But I'm reading from page 4 of Justice Pasquale's decision. And about 2/3 of the way down the page, the Justice writes, the Commission concluded specifically that the installation of the pier would, and then he quotes from the decision, result in the permanent loss of 28 square feet. You covered that a little earlier. Going further along, he says, further, the area of the proposed float will occupy 300 square feet
Along
of
with
the
the
surface
unknown
area.
number of boats, I see it.
Bingo.
And so you cite a recent case from 1976 called Volpe that, as I understand it, stands for the proposition that the Commission's denial order must be upheld regardless of other reasons which the Commission may have advanced. So to Justice Neyman's question, if the judge decided the case based on something not advanced by the Commission, that is not a problem for us. Okay.
Even I wasn't practicing law back then, Your Honor. But in this case, the Commission did specifically reference that absence of information.
I have a question for you about the Commission's application of bylaw section 16C9. the famous paragraph 9. That says piers shall not be allowed to be constructed within significant shellfish habitat. So that doesn't say anything about adjacent to significant shellfish habitat. Does that apply here?
Well, I think one could take the position that the construction of the pier should not have been allowed where it was. But this gets back to the question of adjacency. One is not constructing a pier in the adjacent areas, notwithstanding the fact that the adjacent areas will be affected by the construction of the pier.
And then when paragraph 9 goes on to say the absence of shellfish may not mean that productive shellfish habitat does not exist. That's a little bit of a tautology, I think. But is that how you get to adjacency? That even if there's no habitat under the pier itself, that doesn't preclude the possibility of adjacent shellfish?
Hypothetically, Your Honor, I don't think it would, because there is still the question of an impact on shellfish resources. Now, and I always wanted to use the phrase somehow, you know, we need not arrive at this question today, but you asked it, so we've arrived. In this case, the Division of Marine Fisheries, in its correspondence to the Commission, which the Commission relied on very heavily, very clearly states that the adjacent areas were mapped for shellfish resources. So there is evidence on the record of an effect on shellfish resources, regardless of whether there was one quahog or however many quahogs where the structure is actually being driven in.
So if you could get the town to do whatever you wanted, would you ask them to change that to say within or adjacent to?
Yeah, that would be nice. Your Honors, I had nothing else for the panel.
Let me just check. I don't see any other questions. We will take the matter under advisement. Thank you both very, very much.
Thank you, Your Honors. And I did want to just take the opportunity to thank court personnel for great courtesy extended to me.
Absolutely. I have a wonderful staff led by Chief Court Officer Smith. Our next case is Stanley P. Jones versus Andrea D. Ridley, 24P942. The case is partially impounded. I just want to note for the record, Mr. Jones did not file a brief. I understand he has inquired this morning and may be watching via live stream, but because he did not file a brief, he is not permitted to participate in oral argument, and I believe we entered orders to that effect on the docket. So, Mr. Traft, when you are ready.
Madam Chief Justice and Associate Justices, may it please the Court, Michael Traft on behalf of Andrea Ridley. There are essentially two issues involved in this case that we have raised and feel that my client is entitled to some financial compensation that was not was rejected by the judge.
Can I ask you a question, though?
Sure.
There's been, it appears, a host of post-judgment nisi actions filed, mods that have gone to trial or have gone to judgment. Do any of those address asset division or failure to order retroactive child support, which I understand are the two issues before us today?
Correct. They do not.
So this appeal is not mooted by the subsequent judgments?
That's correct, because they deal with all subsequent actions. There was disputes that related to custody as well as to subsequent support, but not the retroactive support issue or the division of assets that we are raising on this appeal.
Okay. And the appeal was not pending here when the mods were filed? Because normally you would need permission of the single justice to file something below while an appeal was pending. I know it seems like it took forever to get this case entered here. So,
That's correct. The appeal was not pending in this court. It was,
there was a notice of appeal filed below, but
Right.
it had not been entered here.
Correct.
All right, so on the failure to order retroactive child support, I know what the statute says, and I know what Morales says about retroactive in a mod. Do you agree with me that in a judgment, that is within the discretion of the judge, as opposed to statutorily required?
It's within the discretion of the judge, but the judge doesn't have unlimited discretion to
No
reject
question.
it.
I need to do it in baby steps. So
Right.
this is a discretionary call. So now
Yes.
you need to tell me why Judge Tierney abused her discretion in failing to order retroactive child support.
Right, because we're dealing here with what is the appropriate amount that should be received by the mother who was the primary custodian. Judge Tierney made the decision that she had throughout the litigation been the primary custodian of the children, and she in terms of the support order, there had been an initial support order at the
Of
outset.
126.
Right.
And then I understand the judgment was 321, and you complain at page 20 of your brief that the judge made inadequate findings. But if I look at page 7 of her decision, she does explain why she declined to enter retroactive support to the older two children. That case went to judgment in 2008, and there was no evidence about why child support was not entered. And then as to the underlying divorce case, she says, Mom did not seek a child support order for the first year of the litigation, and then once the 126 entered, she didn't seek to modify it over the life of the case, despite having court appearances multiple times. So why is that an inadequate finding? She explains why she didn't do it. You might disagree with her reasoning, but that seems to be an adequate basis.
Well, it's an inaccurate basis, first of all, in terms of, first on whether she sought support. She did so.
Did you say inadequate or inaccurate?
Well, both, actually. First, with respect to the accuracy, the mother did seek a temporary order, and it took about 6 months before there was a final determination of the initial support order. So it wasn't that she was negligent in seeking to try to obtain a support order. And then what happened after the support order, the litigation continued because there was this litigation over the issue of whether there had been a prenuptial agreement. And that ultimately went to a separate trial and judgment after a couple of years of litigation. Now, the complaint by the trial judge is, well, she could have filed for a motion to adjust the child support. But there are a number of reasons why that was not a wise idea under the circumstances. One, because there was an issue of what income the father was obtaining. And in fact, it didn't really come out until the trial that the father had received. First of all, he had been back to work in 2016. So the original order is based upon his unemployment income. He had been back to work in 2016, but he also had income from the residence that he owned that had rental income. And ultimately, he increased that by spending some money from assets that he withdrew in order to add a separate rental unit in that particular determination. So there was other issues that related to that, and it's somewhat related to the issue of whether the prenuptial agreement applied, because that gets back to the second issue, really the
Except that a
division of
prenup,
assets.
as you know,
Right.
cannot ever address child-related issues. That's
Right.
violative of public policy. So you can litigate the validity of a prenup as it relates to alimony and property division while simultaneously litigating custody and child support.
Yes, you could, yes. What I say was unfair criticism for the mother in this circumstances is that she was trying to get the initial issue resolved and then proceed to trial. There were also switches of counsel on both sides.
She had counsel. She wasn't self-represented, right?
Correct. Both parties, actually, and
Mr.
both
Sweeney,
switched
right?
counsel during the course of this
She and
litigation.
Mr. Sweeney?
Attorney Sweeney ultimately became the trial counsel. He came in actually after the decision on the prenuptial agreement. He came in as a new counsel, and then he moved forward. I mean, and there was also switches of judges. And when Judge Tierney first came on to this case, she addressed the issue by saying, well, you know, you've been litigating this case for 3 years. Let's get a divorce judgment. So what she tried to do is push it forward to get a trial and get a full appropriate judgment. And the mother's rationale in this circumstances, rather than try to litigate the same issue twice, have on a temporary order, where there's some questions back and forth about what's her income, what's his income, what's the appropriate amount, put it all together in the judgment once the judge had taken responsibility for the case and scheduled the hearing. It just made sense to, rather than to do things twice, to do it all together and get all of the information. And that was part of
Let's talk about the asset division for a minute.
Yes.
You agree, I think, that this was a short-term marriage. I understand there were children, but a short-term marriage, that they had not commingled their assets, and in fact, they never lived together.
Yes, during the marriage, that's correct.
So tell me why the judge abused her discretion in the way she divided the assets.
Well, you have a marriage that, before between the marriage and the divorce, was approximately 3 years and 5 months. But then there's litigation from the time of the divorce complaint until the actual divorce judgment of over 4 years and 5 months. So you had more than 7, almost 8 years of a marriage. Now,
Oh, this is Savides all the way, isn't it? This is the Savides case. It's rare that Savides applies, but this is Savides. They never lived together. The length of the litigation may have exceeded the length of the marriage, but we're not going to divide things as of the end of the litigation when we have a 3-year marriage with no commingled assets and no living together while they were legally married.
but I think the division of assets has to also consider the custodial situation. If this were a relatively split custodial arrangement, that would be one thing. But the mother was always the primary custodial parent. The father was a visiting parent. She took all of the
How does custody
responsibility.
relate to asset division? Give me a case that says that you can consider custody in dividing the assets of a short-term marriage.
Well, the statute specifically says that. That's all. That's one of the many considerations that of the contribution to the custodial arrangement that is to be considered in terms of dividing assets. So if you have a
Certainly
situation.
the mother's non-economic contributions to raising the children, absolutely a 2834 factor. I don't have any issue with that. But you're asking us to tie the asset division to the child rearing, and I'm not sure how you get there.
Well, because of her responsibility, not only was she taking the primary responsibility for raising the children, she also was providing some financial contribution. She was working as well, and as a part-time employment. And so those contributions can't be or should not be completely ignored just because there was no commingling of assets of the two parties. And the reason for the lack of commingling is really demonstrated by the testimony in the trial about this marriage, was that the mother understood that when they got married, they would live together and they would have a joint partnership. And that's what she anticipated and expected. But it was the father who decided not to.
Do you claim that any of the judge's findings about the assets are clearly erroneous? Because the judge found that, in addition to what I've just said about no joint assets, no joint debts, they never filed a joint tax return, mother made no financial contributions to the purchase of property, there was no evidence that she ever paid any bills for the house. Are any of those clearly erroneous findings?
None of those are clearly erroneous findings. That's correct. And what I'm saying is that a financial contribution alone to the increase of assets of the father, where there was a marriage that extended altogether.
The one thing she did do, right, is she did find that mom had loaned dad some money. She did disagree with mom's amount, and she disagreed with dad that it had been repaid, and in fact, she ordered it repaid. I think it was about $4,700, and we have in the record the check was cashed by Attorney Sweeney's office. So that's in essence she was compensated for money she gave him towards that property.
That specific amount, yes, that's a minimal amount. But in terms of the, I think that in division of assets, you have to consider the entire contribution throughout the entire marriage and not solely limit it to the financial contribution and the potential commingling of assets. And our argument is that there has to be some consideration. You had a situation where the father had withdrawn, he had earned during the marriage a period, once he had been back to work again from 2016 till the judgment, he had earned some more money on retirement. And prior to that, he had withdrawn a significant amount of his retirement. Now, it wasn't clear how much of that he had earned before the marriage, but certainly there was some that he had earned during the marriage, and then he used $30,000 of that to make an increase in the value of the house. And it's accurate that there's no specific evidence as to what the value of the house was at the time of the marriage, but it certainly increased in value from the time during the time of the marriage because of this adding in a separate.
Were there appraisals entered of the property?
Excuse me, Your Honor?
Were there appraisals of the real estate entered as exhibits at the trial?
Yes, there's an appraisal of the value at the time of the judgment, yes. And there was the testimony as to what it was at the purchase, but the purchase was before the marriage. So that's, and the judge faulted the mother for not having some information specifically about what the value was at the time of the marriage. But my argument is that you can consider all of the facts that, in the evidence that was presented about the value of the house to at least make some determination of whether there is an amount that should be considered in terms of an assessment of value for the mother. So it's a kind of situation where you have a mother who's made a specific contribution to raising the children and has been given throughout this 4 years of litigation a relatively minimal amount of support that unquestionably is less than what would be an appropriate amount of support. Attorney Sweeney had provided a assessment of what would be an appropriate support based upon the tax returns filed by both parties. No dispute about what their income was, and the fact that the income was a lot more, and had that child support order been issued based upon what their actual income was, she would be entitled to that additional income.
And I think we're going to have to leave it there.
Thank you,
very
Ryan.
much.
I really appreciate it.
Our final case today is the Department of Children and Families and Another versus Mother and Another, docket 25P 394. I remind the parties that this is an impounded case, so please do not use any names. I also understand that there are some parties in the courtroom, and I assume that counsel has instructed their clients about proper courtroom decorum.
I have, Your Honor.
Thank you. Let's get everybody set up, and then we'll begin. And I just want to make sure, counsel, you're splitting 10-5? Wonderful. Attorney DeFeo, when you're ready.
Thank you, Your Honors.
Good afternoon, Your Honors. I am Jennifer DeFeo. I represent the appellant mother. As you've indicated, she is here in the courtroom with members of her family. We are requesting, Your Honors, that this case be reversed and remanded back down to the juvenile court. I think it's very important for this court to understand why we are not here. We are not here because mother physically abused her son. We are not here because she abandoned him or starved him. He was not a victim of domestic violence, either as a victim or as a witness to it. We're not here because mother had a substance abuse history. We're not here because she has this lengthy history of mental health that has caused her to be hospitalized. She has no lengthy criminal record. She had 2 minor things as a juvenile. She had 1 adult issue, which pertained to her inability to get her son to school. That's why we're here. This child, when he was in the 1st and 2nd grade, struggled tremendously with undiagnosed attention deficit hyperactivity disorder. Mother, loving her child, didn't want to acknowledge at the beginning that he had an issue. She didn't want him on medication because she had concerns about medications for her child. Child didn't want to take his medication. A maternal grandmother who was thrown into this mix and caused chaos in this case didn't want the child to take his medication. But you know what's important? At the time of trial, this child was taking his medication. He was stable. He was in school. And there was nothing in this record that said mother would not be able to maintain the child where he was at. That is a screamingly overwhelming issue in this case, Your Honor. There's no nexus. There's no nexus between DCF's concerns about mother's mental health and her inability to parent her son. There's no information in this file that shows that this child would not have thrived within her care once the medication issues had been resolved. DCF perpetuated this woman's trauma. It said, we are going to take your child and we're going to take you and we're going to push you into this horrible situation with your mother, the maternal grandmother, who abused you, who had 10 supported allegations of neglect against mother for failure to send her mother to school. These are the things that mother faced. So now DCF says, we don't think you're behaving. So we're going to let your mother, who traumatized you, take control.
Attorney DeFeo, did that get raised below?
So it was, I believe, Your Honor, it was implicit in every aspect of this case.
You know, under adoption of Daisy, was it raised below?
So, Your Honors, the question is, was it raised? Our argument is it was implicit. However, under guardianship of Kelvin, even if it wasn't raised, this court absolutely has the ability to address the issues within this because of it being fully briefed, because this is something that could happen again to another unwieldy...
Don't address issues raised for the first time on appeal.
Your Honor, but you do have the opportunity to do so under guardianship of Kelvin. Guardianship of Kelvin, and I can quote you...
I think it would be more helpful if I could say, to focus on what the department and child say are the reasons that mom was terminated, which includes failure to address the child's needs, failure to visit, educational neglect, untreated undiagnosed mental health, housing instability, lack of services, and that it was not temporary. Could you focus on those?
Absolutely. So a lot of those issues deal with mother's inability to work with DCF. And nothing was going to change that because she was traumatized by DCF. She was a child consumer of DCF. During that time, her sibling was kidnapped and had significant things happen to her that made mother not trust DCF. DCF, what's interesting is the social worker who was primarily involved in this case from November 2022 to September 2024 stated, I didn't witness any mental health concerns with mother. So why was mental health a concern? Well, it's a concern because mother has a history with DCF as a child. Mother didn't have a history of anything other than not sending her child appropriately to school. There is no doubt. But what happened was she tried, and her efforts do not show that she was so grossly unfit that she placed this child at such
unbelievable peril that it warranted the removal of her rights forever. She showed that she made the efforts for her son. Did she go and seek therapy? Your Honors, I could go into so much off of the record that I would love to do that Mother would...
You can't.
No, I'm not. Mother would like me to. I've explained that I can't. What's here before you is here before you. But what isn't here before you, again, is the nexus. The judge can throw out all of these factual findings. Mother had a mental health issue. Mother didn't cooperate with DCF. Mother didn't have stable housing. Where is the nexus? The housing issue is poverty-related, Your Honors, and we know that poverty and housing issues alone are not enough. So really the focus here is her mental health. But where in the record does it show that Mother's mental health had anything to do whatsoever with her inability to get child to school? She said, I don't think my lovely little child who's bright and articulate, and everyone in this case has said this child is bright and articulate. She didn't want to believe that maybe he really did have an issue. This child was put on a medication for ADHD that was a stimulant. It hyped him up so much that he couldn't sleep at night, so they had to give him a sedative medication so he could sleep. So what happened when he was on that second medication? Mom couldn't get him up in the morning. We're not talking about a parent who locked her child in a closet and said, I'm doing nothing for you. She got flashcards. She got worksheets. She tried. When she couldn't get her son to take his medication, she tried to hold him down and make him. Then she said, I give up. I can't make him do it. I'm going to have the school do it. So she went down to the school and said, here. So what else do we have?
Could the judge find the nexus from the boy's testimony?
I think I would need a little more specificity as to what you found that the child said was to that level. I think that the child was coached in this matter. I think throughout all of this case, there is sufficient information to show that this child was fed information by many different sources. In the record appendix, the court investigator and the GAL found that child knows too much about the adult issues in this case. Record Appendix, Volume 1, page 49. Record Appendix, Volume 1, 147. Mother was aware that, child was aware that mother had started to engage in services. He knew that she was communicating with people. He was conscious of the fact that the case had been open and mother hadn't done things. Why is this child in privy to any of that information?
Well, he knows she's not visiting him.
But, Your Honor, I think what's important to note is the judge found that she did not willfully fail to visit him. He made a specific finding under the Section 3 factors, Record Appendix 1, page 66, found that this factor is not applicable. He did not find that mother willfully failed. So how can you at that point say, well, she did, when the judge made a specific finding that didn't happen? And I think that that actually plays into the post-adoption and post-termination visit argument.
Before you get there,
Yes.
You cited guardianship of Kelvin, which I recognize. I know that's your case. You argued. Are you citing to the 2013 case or the 2018 case?
The 2018.
Thank you.
That's not in your brief, right?
No, because it was something that
that's
was
why I was
raised
asking.
in the other
File a
counts.
reply brief is,
Right, I did not file a reply brief on that issue.
So, and I have a question on the visitation before you get to your
Yes.
argument. Is that argument contingent on our reversing or remanding on the unfitness and termination argument? Or is it separate and apart?
You're talking about the post-termination, post-adoption visits? So it would, regardless, this issue should have been addressed by the juvenile court. So if you were to remand it on the argument that she is fit and was fit at the time of trial or wasn't indefinitely unfit, then it doesn't need to be addressed. But if it isn't remanded for those purposes, which it is our sincere hope that it is, that this has to be addressed because the judge made blatant failures in his post-termination, post-adoption visit order. And I think that the reason that this court has to review it is the primary purpose for a post-termination, post-adoption visitation order is to offer clarity and protection for the child. And that clarity requires some specificity. And there's a lot of case law out there that says that while the judge has the discretion on how to order it, once he has made a best interest determination, you need to look at cases like adoption of Rico, adoption of Quinton, adoption of Flavia, and you have to take that second part of the analysis and put it into play. And that's where the judge failed.
But is your complaint that the judge did not order a minimum number of annual visits? Is that what it boils down to on this particular question?
So there's two parts to that. That's part of it. But the second part is, if he doesn't, he had the absolute discretion to leave it to the judgment of the legal custodians if he made a finding that the legal custodian could act in the best interest of the children based on the facts before the court. And he didn't do that. And in this case, there was no pre-adoptive family. There was nothing suggesting that the foster parents were encouraging any type of visitation. And without going back into the whole DCF fiasco in this case, clearly DCF was not using good discretion. I think the other issue that this court needs to understand is that the purpose of the post-termination, post-adoption visits is so that the child has the ability to maintain contact with the mother. Doesn't mean he wants to or he has to. So this isn't, oh, well, the child said, I don't want to see mom. This is, he has to know in his heart, in his world, that his people understood that he has the right to see her, and that if nothing else, that right is twice a year, once a quarter, that he can have a phone call with her. That's what the issue is, and that is what's grossly missing in this case on that part of the decision. I think that adoption of Flavia really is the key case in this matter. The judge, while having the sound discretion, consistently, in that case, looked at, yes, these are important because of the best interest, but again, the court said, where's that next part? Because you know what? That next part is just as important as the best interest finding that these visits should happen. I think the other issues that are important in this case is mother was not perfect. There's no doubt about that. But the United States Supreme Court has made it very clear that just because a parent isn't perfect or that DCF initially removed her child, that doesn't mean that she's unfit. What it means is something needed to happen, and something did happen. This child was able to get the help, starting with her. She did get him into the IAP. She did get him evaluated. She did get him on medication. Did she like it? No. Did she fight against it? Absolutely. But I think that if we looked at it and we took out DCF, and she was dealing solely with the school system, solely with the school nurse, I think this would have been very different. But you couldn't overcome her trauma with DCF. And that was a huge issue in this case, is that DCF kept saying, okay, well, you have trauma, but go have these visits with your mother. Your mother caused you trauma, but your mother's going to have care and custody. Your mother can go to your visits with your child anytime your mother wants to. So how is her trauma with DCF trickling down to her son? Well, the reality is it's not there. The nexus isn't there. When you take out DCF saying, we want you to jump through these hoops, which, yes, she should have, could have, would have, didn't, what is the nexus with her noncompliance and the child's not attending school? It's over. He attends school. He's on medication. Yes, he improved in foster care, but given a little more time, without maternal grandmother's interference, without maternal grandmother overstepping DCF and going and getting the guardianship, and then herself saying, I'm not giving this child medication, we would be in a very different position today. So where is the unfitness? It wasn't there. What was there is a parent who was imperfect, fighting against a system that had betrayed her and her family, and now she couldn't overcome her anger at them. To say the magic words that the trial judge wanted, I did this, because to her, saying I did this meant DCF was justified. And you know what? Should she have done it? She couldn't because of the trauma. Would therapy have fixed that? Maybe. But would that have changed anything? Because her mental health wasn't why this child was removed. There was no nexus between her mental health and her decisions, actions, failures to send this child to school. And I see that my time is up. If there are no further questions, I will rest on my brief.
Thank you very much,
And thank
Counsel.
you.
Attorney McGann.
Attorney Matthew McGann for the Department of Children and Families. The Department of Children and Families is seeking an affirmation of the trial court's findings below in both the issuance of the decree with regards to the sufficiency of the evidence before that trial court, in addition that the post-adoption contact order that was issued by that trial court was appropriate in the balancing of the factors that was before the trial court at the conclusion of the trial. What is before this panel is a issue with regards to both mental health, but more importantly, an issue as it regards to the child's specific needs. Now, the case law.
Before we get there, can I ask you, Attorney DeFeo is raised in her brief significant concerns about the placement with the maternal grandmother. I asked her about whether or not that was raised below, and she says that we can still, under Kelvin, address that issue. What do you say about that?
I would say that no, it would be this panel would not be able to address that because it was not preserved below at the time of the child was placed with the grandmother. But furthermore, even if this panel was enticed to address such issue, I would note to the court that the timing that the child was placed with the maternal grandmother is de minimis to the total timing that the child was out of placement of the mother. So the child was removed from the mother's care and into the department's care in October of 2021, placed with the maternal grandmother in November of 2021, and through the failure of the maternal grandmother to follow through with a foster care licensing study, was removed from her care in April of 2021. Any degradation of the relationship between the child and the mother should have been solved, but between the time of April of 2021 and the time of at least April of 2024, in which it is noted that the child made the decision to no longer visit his mother. And in particular, I would note for the court that the child testified during his own testimony that it was not anything with relation to the relationship with his maternal grandmother or anything of that nature. It was the failure of the mother to do the tasks requested of him and the failure of mother to stay consistent and meaningful in her visitation. Now, as it relates to the visitation issue that has also been brought up, I would note that, and specifically the communication, any sort of communication that was had with the child as to this idea that the child knew too much, the trial court had found that it was as early in the fall of 2022 that there was raised concerns with the communication that the mother was having between the child and herself during the visitation hours, and thus that there was services put into place to help try and address and amend that issue. So it wasn't necessarily this notion that it was the child being fed information. I would suggest to this court was the source was actually at times the mother herself. Specifically in the findings of facts, we find the trial court noting that it was the mother who consistently brought up that it's the Department of Children and Families' fault for the reason why you are not in the care of me at this time. And so what we have, again, going to the child with a higher level of needs, and that the panel, and in particular the trial court, is required that it is the parent to meet the child's needs. What we have here is a child diagnosed with a very specific ADH diagnosis with a stress component, and requiring a significant amount of services to progress through his educational sort of development. To a point now in which the panel can take into consideration the time that he was under the care of the mother, and in particular the time he was at the time of the final trial. And what we have is a child who has been able to progress through each educational grade, and in particular the trial court found that the child was an active member in the community that he resided in. Now, what this led the trial court to conclude is that the child, and I quote, needs an attentive and responsible caretaker to further address the underlying needs of the child. And what he was unable to find is that the mother was able to rise to that occasion and to be a further, that appropriate caretaker for the child. And so this is central to the issue, is the idea of meeting the child's needs. And while I acknowledge that it is common within this panel to see cases of this nature in which there was some sort of action taken or a specific event in which we could point to, such as an analogy would be a physical abuse event in which the child suffered, and that may be lacking in this case. I would suggest to this panel that what we have here is more of a slow burn of inaction by the mother. She failed to consistently visit with the child, even knowing the importance of those visits. I think it would be of particular weight for this panel to see the transcript of the social worker in the reaction of the child after the visits that the mother failed to attend. In particular, that they would have to coordinate not only with the foster parent, but also with the therapist that the child was seeing at the time to ensure that the child would not go into an emotional dysregulation. And that inaction by the mother also leads to her inability to address the housing instability that was present at the time of the filing throughout the time of the entirety of the petition. It also is present with regards to the inability to address the underlying mental health needs that the mother herself has self-acknowledged that she is diagnosed with. Within the court investigator's report, we note that the mother stated herself that she has been diagnosed with depression and anxiety, that she has been prescribed medication to address such diagnoses. And I think the phrasing that she uses is that her anxiety can be, quote, bad at times. And without this ability to address those underlying needs, what we have at the conclusion of the trial is a mother failing to accept any responsibility for the idea of the child being out of the custody of her. And thus, this leads to what was present before the trial court, again, at the conclusion of the trial, which was an adoption plan of recruitment without a pre-adoptive resource, and with a child who was acknowledging and testifying that he had no longer any interest in visiting or having any communication with his parent. And thus, what we have is sort of a balancing factor, or a test of balancing factors that the trial court must go through to be able to realistically import a post-adoption contact order. Now, the trial court does find, we note, that there was a bond between the mother and the child, but when there is a bond found, which is usually the first requirement, it may be warranted, is the specific language within veto that says that if a post-adoption contact is required. And what the trial court did is essentially balance the factors of what is in the best interest of the child with also any sort of constitutional protections of a future adoptive resource. And what we have here is a planned out order by the trial court stating that it is really in the discretion of the guardian with deference to the child, stating that he suggests that there could be visits, but that it is giving a lot of agency to the child and the decision-making to any sort of contact. And I would note that the operational procedure is quite laid out within that order in terms of trading of communication and things of that nature, so that the child would be well aware of, or the mother would be well aware, if the child did want to have any contact, that there was a mechanism in place for that, for the mother to become, aware of that, and for thus the communication to go forward. And so for these reasons, the post-adoption contact, I think, really does achieve those factors of what is in both the best interest of the child at the time of the conclusion of the case. And without any further questions, I'd rest on my brief.
Thank you.
Thank you.
Attorney Krasner?
Good afternoon, and may it please the court. I'm Sherry Krasner. I have the privilege, really, of representing this child, soon to be a teenager, in these proceedings. I think, as Justice Grant noted, to look at the testimony of the child in chambers is really useful. I particularly draw the court's attention to page 143 of the transcript, where the child is insightful enough to see a connection between an animated Disney film and his circumstances, and knowing that you can't go back and undo what has happened. With respect to the constitutional question, as Chief noted, can't implicitly raise an argument that was not preserved below. I'd also state that even if the court were to do that, or could find a reason to do that, Kelvin was not mentioned in the brief, and also there is no specific case that's noted in the brief about the constitutional argument, so I would suggest that the argument is not properly before the court in any way. As to the unfitness argument, counsel in her brief and today, I think, made a very persuasive argument about a different way to frame the case. She did. However, respectfully, the job of this court is not to say how to look at it in a different framework. If the judge, the trial judge who had the opportunity to hear all the witnesses, to review all the documents, if he made findings, none of which are challenged as clearly erroneous, and which in the aggregate support the underlying decision, then the limited role for this court is if that happened, then this court must affirm. So again, even it's not the job of this court to sit as a finder of fact. It's the job of this court to determine whether the judge below made any errors of law or abused his discretion, and nothing that was argued in the brief or argued today suggests that that argument is even before the court. As to the issue of post-termination, post-adoption visits, again, the standard is whether the trial judge abused his discretion. I see no basis for this court to reach that conclusion, because the judge, in order to not abuse one's discretion, one must look at all the factors. And that's exactly what the judge did. And he had a lot to juggle here. He had to consider that this child, like the child in RICO, was not, at the time of trial, in a pre-adoptive home. He had to consider that the child had lived with the mother for the first 7 or 8 years of his life and had a relationship with her, and he did that. He also considered the fact, though, that that was not the only relationship in the child's life, that the child had lived in the same foster home, albeit it was not a pre-adoptive home, but he had lived in the same home for 2 years and had developed, at the time of trial, and had developed a relationship with that foster family. He had to consider, and very importantly, the fact that the child made a very clear expression that he did not want to see his mother. And so juggling, and judge made findings about all of those things and came up with a decision that there was an existing bond, and it would be in the best interest for the child to have some sort of contact, but then he left any decisions about the amount and frequency to any prospective adoptive parents, and specifically strike that in conclusion of law 40, the judge says, therefore the court finds that terminating post-termination and post-adoption contact between mother and the child would not serve the subject child's best interest and would deprive the child and his pre-adoptive resource from deciding to resume visitation with mother in the future. So I think he was sort of giving a signal to any subsequent post-adoptive resource to consider that the child in the future might want to have visitation. So I think the judge did everything he was required to do. He did not abuse his discretion. I'm exactly at the end of my time, and unless the court has any questions.
We will leave it there. Thank you.
Thank you very much.
I just want to say that these are the most difficult cases that this court has to decide, and that we understand that unfitness does not mean that a parent doesn't love their child. And so we will carefully examine the record and the arguments made by all counsel and enter a reasoned decision. So the case is now submitted and under advisement. Thank you all.
Thank
I'd
you,
like
Anna.
to say to our court staff, thank you very much, particularly our court officers, our wonderful timekeeper, our law clerks, and the clerk's office who make the wheels on the bus run on time. And with that, this session is now in recess. Thank you.